Hey, good morning, everyone. This is the December 12th meeting of the Oregon Water Resources Commission. And before we get started, a little reminder how to work these microphones for commissioners and for speakers. You have to push the button at the bottom and make sure the red light comes on, and that's how you know that it's working correctly. So just try to remember to push that red button so that we can hear you. We're going to start off this morning with Will Davidson. And he's the protest program coordinator for the department, and he will be introducing agenda item B. So go ahead and take it away, Will.
Good morning, Vice Chair Smitherman and members of the commission. For the record, my name is Will Davidson. I am the department's protest program coordinator. Agenda item B concerns a contested case hearing on the proposed cancellation of water rights certificate 3943 based on alleged forfeiture by non-use. Certificate 3943 allows use of water from Grave Creek, a tributary to the Rogue River, for irrigation of 65 acres in Josephine County. The department initiated a cancellation proceeding concerning Certificate 3943 based on allegations of forfeiture and affidavits asserting non-use submitted by Water Watch of Oregon. Andreas and Carol Bleck, the holders of Certificate 3943, protested the proposed cancellation and requested a contested case hearing. Water Watch's allegations of forfeiture and affidavits asserting non-use were initially filed in a contested case proceeding concerning transfer application T12837. In that proceeding, the Blecks seek to change Certificate 3943's place of use, type of use, and point of diversion, and Water Watch has protested the department's proposed approval. Whether Certificate 3943 is subject to cancellation based on forfeiture by non-use is also an issue in the transfer proceeding, which is currently pending before the department. In March 2025, the department held a 5-day hearing concerning the proposed cancellation of Certificate 3943. An administrative law judge employed by the Office of Administrative Hearings conducted the hearing. At the hearing, Water Watch presented evidence and argument supporting cancellation, and the Blecks presented evidence and argument opposing cancellation. The department presented expert testimony by department technical staff concerning analysis of aerial imagery and satellite data, but remained neutral on whether the evidence demonstrated non-use. After the hearing, the administrative law judge issued a proposed order recommending that no portion of Certificate 3943 be canceled for non-use. Water Watch filed exceptions to the proposed order, and the Blecks filed a response to Water Watch's exceptions. Water Watch's exceptions assert that the proposed order contains many errors and urge issuance of a final order canceling Certificate 3943 in whole or in part. The Blecks' response to Water Watch exceptions supports the proposed order and argues for issuance of a final order determining that no portion of Certificate 3943 should be canceled. The Commission has been provided with copies of the proposed order, Water Watch's exceptions, and the Blecks' response. Where exceptions to a proposed order are filed in a cancellation proceeding, the Commission has not delegated authority to the Department to consider the exceptions and issue a final order. Therefore, the Commission must consider the proposed order, Water Watch's exceptions, and the Blecks' response, and determine the next step in the proceeding. Potential next steps the Commission may take include the following. 1. Deny Water Watch's exceptions and adopt the proposed order as the final order without modification. 2. Issue a final order that adopts the proposed order's recommended determination that no portion of Certificate 3943 should be canceled, but modifies aspects of the proposed order to address issues noticed by the Commission or raised in Water Watch's exceptions or the Blecks' response. 3. Issue an amended proposed order proposing to cancel in whole or in part, or to modify Certificate 3943. 4. Ask the administrative law judge to conduct further hearing as specified by the Commission. Or 5. Form a subcommittee to review the exceptions and provide a report to the Commission prior to issuing a final order. Whatever next step the Commission chooses, a final order will ultimately need to be issued to resolve this case. Under ORS 192.690 sub 1 sub B, public meeting requirements do not apply to deliberations of state agencies concerning contested case hearings. Accordingly, the commission may recess to deliberate concerning this case. However, before deliberating, the commission has the option to allow the parties to present oral argument. It is department staff's understanding that representatives of WaterWatch and the BLEX are present today and are prepared to present oral argument, should the commission allow it. Because the parties have already provided argument in their written exceptions and response, staff recommends that if the commission chooses to allow oral argument, the commission allow each party 15 minutes to present argument and take questions from the commission. Staff further recommends that WaterWatch, as the party that filed exceptions, provide oral argument first, followed by the BLEX. The commission may structure oral argument differently than staff recommends, but each party should be given the same amount of time to present oral argument. Thank you.
Thank you, Mr. Davidson. So, Commission, as Mr. Davidson described, we need to decide whether to allow the parties to present to us today and present their oral argument. I move that we allow the two parties to present oral argument. Do we have a second? We have a second?
Second.
Second. All right, let's take a vote. Commissioner Mall,
Yes.
Commissioner Kihara,
Yes.
Commissioner Newman,
Yes.
Commissioner Lee,
Yes.
Commissioner Wolf.
Yes.
Okay, the motion passes. So we will now have oral argument on a contested case order. I am reopening the record in the contested case hearing for the purpose of hearing arguments from the parties. This proceeding is being recorded and is part of the record for the contested case hearing. So we will first have 15 minutes for WaterWatch, followed by 15 minutes for BLEC. And commissioners, you can ask questions at any time. And so we will start with WaterWatch. So whenever you're ready, please come up and remember to push the button.
All right, I think that's working. All right. All right, good morning, Vice Chair Smitherman, members of the commission. My name is Victoria White. I'm from WaterWatch of Oregon. I'm a staff attorney, and here with me is Lisa Brown, also staff attorney at WaterWatch of Oregon. We are the proponents of cancellation in this case. Thank you so much for allowing us the opportunity to talk with you today. The issue in this case is whether the Water Right Certificate 3943 should be forfeited for non-use for the time period of 2004 through 2009. The proposed order's conclusion that the water right was not forfeited because the preponderance of the evidence establishes the beneficial use of the water right in 2008 and 2009 is an error. We respectfully request that the commission issue an amended proposed order or final order canceling the water right, or at minimum, partially canceling the water right. In the alternative, we encourage the commission to form a subcommittee to ensure all of the evidence and arguments have been reviewed and addressed, and to ensure that the final order is supported by the record and follows applicable law. Given time limits, I'll highlight a few key points and refer you to our briefing, pre-hearing memorandum, and exceptions for a fuller picture of the details. We're happy to answer any questions you may have along the way. This commission should issue an amended proposed order because first, the proposed order failed to apply the correct evidentiary standard, failed to properly weigh the evidence, and failed to properly apply the forfeiture statute. Secondly, WaterWatch met its burden of affirmatively proving non-use by producing and citing a significant amount of reliable evidence that the water right was not used for irrigation in the form of witness testimony, high-resolution aerial photography, and specialized satellite imaging data. Finally, protestants' evidence fails to outweigh this evidence of non-use. There is no documentary evidence of any irrigation occurring during the time period at issue. There are no photos of irrigation or irrigation infrastructure. There are no written records documenting irrigation. Instead, the proposed order improperly relied on prior hearsay testimony that is clearly unreliable and does not support the proposed order's conclusion. So we heard a bit of background, but I just want to go over it again. Certificate 3943 is a water right for irrigation, and it has a 65-acre place of use. It has one authorized point of diversion on Grave Creek, which is a tributary to the Rogue River. The property associated with this water right has changed hands over the years. Prior to 2008, absent owners left the property abandoned and untended. In 2008, the property was purchased by Jack Smith and Douglas Stick for the purpose of gold mining. And in 2010, the property was purchased by the Blecks, who are the protestants here. Mr. Bleck and prior owner, Mr. Smith, became business partners in Sunny Valley Sand and Gravel. Now, this cancellation proceeding arose from a transfer proceeding for this very same water right. The protestants applied to transfer the water right from irrigation to mining and to move the point of diversion upstream. Oregon law prohibits transfer of a water right that is subject to forfeiture. In practice, this prevents resurrection of old abandoned water rights and circumvention of the review process for a new water right. WaterWatch protested the transfer in part because it will injure an in-stream water right, and the non-use of the certificate means it cannot be validly transferred to a new use. After WaterWatch raised forfeiture in the transfer proceeding and filed affidavits of non-use, the Water Resources Department initiated cancellation proceeding. Here, the proposed order is flawed because it failed to apply the correct evidentiary standard, failed to properly weigh evidence, and failed to properly apply the forfeiture statute. In this case, WaterWatch had the burden of proving non-use by preponderance of the evidence, which means that the fact finder is convinced that the facts are more likely true than false. The proposed order instead improperly applies a stricter conclusiveness standard to each piece of evidence WaterWatch relies upon, while failing to evaluate the collective weight of WaterWatch's evidence. The proposed order also applies this stricter standard only to WaterWatch's evidence, not to the protestants. Additionally, the proposed order fails to consider the whole record by failing to address evidence and arguments put forward by WaterWatch in briefing. By law, the ALJ must consider the whole record or such portions thereof as may be cited by any party. Under the correct application of the preponderance standard and a consideration of the whole record, WaterWatch meets its burden in proving non-use. Speaking of our burden, WaterWatch met its burden by producing and citing significant affirmative evidence that the water right was not used for irrigation. WaterWatch's evidence includes testimony from multiple witnesses who recounted on-the-ground observations of the property and confidently testified to seeing no irrigation in 2008 and 2009. It includes high-resolution aerial photographs capturing the property in the spring of 2008 and 2009 that show a complete lack of irrigation in the place of use. It also includes advanced satellite data that confirms the place of use responded like an unirrigated plot of land during those years. WaterWatch also relied on the technical memorandum prepared by Water Resource Department scientists. This tech memo contains a comprehensive analysis of satellite data that measures vegetation growth on the subject property during the months and years at issue. The tech memo also analyzed aerial photos for any indication of irrigation for certain years at issue. The department's tech memo and analysis could not detect any apparent irrigation on the property. While it could not conclusively rule out some small early springtime application of water at times when the place of use was naturally wet, even if this application had occurred, the record shows that it was not beneficial irrigation. When the tech memo is considered in tandem with WaterWatch's evidence, there is no question that it is more likely true than not that irrigation of the place of use under Certificate 3943 did not occur on the subject property during the time period at issue. Which brings me to my last point, which is protestants' evidence fails to overcome non-use established by WaterWatch's evidence. Protestants' purported evidence falls short in many ways, and as such, the proposed order's final determination is not supported by the record. Protestants claim that previous mining business partners who managed the land during the years at issue were very experienced with water rights and knew the importance of and were highly concerned with maintaining that water right. However, there is no documentary evidence of irrigation from the relevant time period, as you would expect. The record instead reflects that the only water use that occurred in 2008 and 2009 was illegal water use for mining purposes, occurring at least in part from illegal sources and not for irrigation purposes. This is not beneficial use. It is clear from his testimony that Mr. Smith's claimed irrigation equipment, including pumps, pipes, and sprinklers, were used for mining reclamation, not irrigation. Additionally, the hearsay evidence that the proposed order improperly relies upon to make its final conclusion is the prior testimony of Mr. Smith, Mr. Robertson, and Mr. Badger. This hearsay evidence conflicts on material issues and cannot all be true at once, making the testimony unreliable for the purpose of establishing whether irrigation occurred. And I would direct the Commission to WaterWatch's closing response, where we detail these inconsistencies. The proposed order fails to properly assess the reliability of this hearsay evidence, which is not sufficiently credible and fails to outweigh WaterWatch's affirmative evidence proving non-use. Where protestants did claim any irrigation, which WaterWatch disputes, It was only for a small portion of the place of use each year, which directly contradicts the ALJ's implicit conclusion that the entire 65-acre place of use was irrigated across 2008 and 2009. The proposed order's final conclusion is that forfeiture was forestalled because the water right was beneficially used in 2008 and 2009. A water user can forestall forfeiture so long as the entire place of use was irrigated under the water right at least once for each 5-year period during a 20-year look-back period. The ALJ found that the forfeiture is forestalled based on irrigation in the spring of 2008 and 2009. Therefore, the proposed order's conclusion requires irrigation of the whole 65-acre place of use in 2008 and or 2009, which is contradicted by the record. Even Mr. Black claimed that only a quarter or a third of the place of use was irrigated each year in 2008 and 2009. The proposed order fails to explain how it found that all 65 acres of land were irrigated in 2008 and 2009 when protestants themselves claim even less occurred. Again, there's no credible evidence that this irrigation happened, but this highlights the proposed order's failure to apply the law to the facts. So to conclude, WaterWatch does not take the cancellation of a water right lightly, but it is illegal to transfer a forfeited water right to a new use. We respectfully request that the commission issue an amended proposed order or final order canceling or partially canceling the water right, or else form a subcommittee to consider all the evidence. We're happy to answer any questions with our remaining time.
Commissioner Newman.
Yes, thank you. Two things. One, could you restate your argument about the deposition evidence? What your position is on the two depositions?
Are you referring to the deposition of Mr. Smith?
Yes.
Okay, yes.
And there was also one of his lawyer, correct?
His lawyer, Mr. Robinson, also was a witness who testified at hearing where the proponents failed to appear. So essentially they defaulted.
I see. Okay.
So there's a little bit of issues with reliability when it comes to that. But as far as Mr. Smith's testimony, he spoke a lot about taking water out of sources that aren't Graves Creek, including filled in mining pits, taking water out of Shanks Creek, which is not the river that's identified in the certificate. And he talked about using pipes and water for mining purposes, which is illegal use, and illegal or use that is unauthorized under the certificate is not beneficial use that forestalls forfeiture.
Okay, great. Thank you. And then my other question is, if we were convinced that only a portion of water was used and only a portion of the land was irrigated, what kind of evidence is there to sort of choose a number for, how much would be canceled and how much would be remain?
Yeah, that is an issue here because we assert that the entire place of use was forfeited, and the protestants do have a burden of, they have the same preponderance standard of showing that there was use. And so we would posit that that's something that the judge has to decide and figure out from the evidence if there is enough evidence to determine where there was water use, and there isn't.
Thank you.
Other commissioners have questions? Go ahead, Commissioner Mall.
A little outside the bounds perhaps, but have there been any attempts in this period to either sell or from the outside acquire this property in Hope?
Well, Lisa, take that.
Chair Smitherman, Commissioner Mole, for the record, Lisa Brown with Water Watch. I would say that that's outside.
Good job, Joe.
Sorry for the abrupt interruption. I'm Sarah Rowe, for the record. I'm the DOJ AG on this case. And so the record is open for this oral argument, but the decision that the commission is reviewing is based on the evidentiary record that's already been established. So we do not want to bring in any new facts at this time, but we 100% able to argue about the facts we already know. So the question you just asked is actually a fact that we don't know based on the record.
Okay, I wasn't going to be involved. Perhaps it was in the record and I just didn't see it. So, okay, sorry about that. Thank you.
You mentioned that there was no documentation. What type of documentation would you have been looking for?
Yeah, or Lisa, we're gonna take that.
Yeah, thank you for that question. You know, I think that you can look at the transfer rules and what's required to show use as sort of an illustration of the types of documentation that are appropriate. You know, certainly pictures of infrastructure, pictures of irrigation. You often see pictures of ditches, pictures of pumps, pictures of a crop being grown, maybe receipts of a crop, that sort of thing. That's the usual type of documentary evidence required in a affidavit of use.
Okay, thank you. Any other commissioners? Okay. Oh, thank you for the timer. Appreciate that. I don't think we have any other questions for you. Appreciate you coming and speaking with us today.
Yeah, thank you very much.
Thank you. Okay, next up. No, they're a little touchy.
There we
so
go.
It's okay.
Good morning, Elizabeth Howard. I'm here on behalf of the water right holders, Andreas and Carol Black, and Mr. Black is here with me this morning as well. I'm just going to jump right in just because we have a short amount of time, and I apologize in advance. I have glasses and I will be looking over them. I don't mean it to come across the wrong way, but it's just the
Not at all. Whatever you need to do.
Okay, thank you. Thank you. Yes. All right. Well, I actually want to focus on the exceptions and addressing some of the arguments that were raised in the exceptions specifically. And as I review the exceptions filed by WaterWatch, they largely take issue with whether or not the preponderance of the evidence standard was applied correctly, whether or not Administrative Law Judge Webster considered the whole record, and ultimately, I want to walk through some of those particular provisions and explain why she did. And before I jump into that, I do want to just briefly refer to the standard of review that applies to your analysis here today. OAR 137-003-0665 talks about when it's talking about an agency, but in this case, it also refers to the commission as going to modify a finding. And what it says in sub 4 is that the agency may only modify a finding of historical fact made by the administrative law judge if you determine that there is clear and convincing evidence in the record that the finding made by the administrative law judge was wrong. And so I just want to point that out because that's a fairly high standard. And here we do have clearly historical facts that have been decided by the administrative law judge based upon the evidence. In particular, she did find that there was irrigation in 2008 and 2009, and she based that on the record that was before her. And in order for you to determine otherwise, you would have to have clear and convincing evidence that she got that fact wrong. At its core, Water Watch really does want you to reweigh the evidence and find that irrigation did not occur between 2008, or excuse me, 2004 and 2009. But again, that reweighing of the testimony would require you to make a decision that's directly contrary to ALJ Webster's weighing of the evidence. One of the other things that I just want to point out is that the purpose of an exception, or what an exception is supposed to do, is demonstrate a legal or factual error in the proposed record. And again, that's not really what Water Watch is arguing. They are arguing that ALJ Webster weighed the evidence incorrectly. Now, I do want to address some of the legal arguments that they make about whether or not the proposed order was constructed correctly or not. But that is different than saying all of the facts are wrong. And I want to point out specifically where ALJ Webster did specifically weigh Water Watch's evidence. So they argue 4 lines of evidence. They've talked about that today. And I want to point out on page 20, I'm just going to walk through them real quickly. The first one of those, on page 20 of the proposed order, the first one of those lines of evidence was with regards to aerial photos. ALJ Webster did review all of the evidence, and she determined that the aerial photos in this record do not provide sufficient information, to determine whether there was a lack of beneficial use for 5 years. She also looked at the NVDI analysis, and that was within the technical memo that Water Resources Department put together. And using the words that Water Resources Department's expert, Mr. Fellows, used in his report and also in his testimony, she found that the results of those studies were inconclusive as to whether or not irrigation occurred in the place of use. She also looked at the evapotranspiration data, which again was largely Water Watch's expert in this case that looked at that. And she again found that that evidence does not persuasively establish the complete absence of beneficial use of the water rights in the place of use during the period of issue. She also looked at the fact witnesses that Water Watch brought to this hearing, and I just want to note that those witnesses, their key witnesses, were quite young at the time of this alleged period of non-use, and there were other witnesses that they brought as well. But as she reviewed those witness testimony, she said that, again, the fact that those witnesses made observations didn't necessarily mean that those observations didn't necessarily mean that there was not beneficial use of the water for 5 years. So again, as she reviewed that evidence, that was her weighing of the testimony. She also reviewed the evidence presented by the BLEX, and what she said with regard to that is that it would strain credulity to believe that 3 witnesses had essentially falsified testimony under oath. Those 3 witnesses did testify that there had been irrigation during 2008 and 2009, and she found that persuasive. She did not think, this goes to the question about the hearsay and the reliability of the evidence, but she said each of those witnesses had testified under oath. They had been subject to cross-examination. They had been, again, 2 of them were alive during an earlier proceeding and had been under oath. Sorry, my glasses are bothering me. And had provided the testimony that irrigation had occurred. So again, I just want to note that she did very carefully review the record, and she did weigh the evidence. And this is actually one of the arguments that Water Watch raises, is whether or not in their exceptions, whether or not ALJ Webster applied the preponderance of the evidence standard. And it's very clear that she did walk through and apply the preponderance of the evidence standard. She in fact refers to it, I I think 6 or 7 different times as she's going through the evidence. And as she starts her opinion, there's the concise statement of facts, there's some introductory statements, and then the opinion part of her proposed order. She says, as the proponent of the position that the water right is subject to forfeiture for non-use, Water Watch bears the burden to prove by a preponderance of the evidence the facts necessary to demonstrate forfeiture. And she repeats that sort of a statement throughout the opinion. So it's very clear she understood what the standard was. It's also clear that she applied it. Water Watch argues that she did not apply it because she uses the terms conclusively or inconclusively. And also argues that ALJ Webster did not consider the whole record. So I just want to hit on those really quickly. So with regards to the use of the word inconclusively, as I understand it, that was ALJ Webster's way of explaining she was not convinced that the facts that were asserted by Water Watch were more likely true than false. And that, in fact, is the standard. That is a way to describe the preponderance of evidence standard. And the word conclusively or inconclusive was actually used in the Water Resources Department's technical memo. And Water Resource, one more time, ALJ Webster actually refers to that statement in their technical memo. Again, they said collectively, these results do not show a clear indication of irrigation in the place of use, and they remain inconclusive that no irrigation was applied. So again, the use of that term conclusive or inconclusive wasn't meant to show that ALJ Webster was applying a different standard. She was just describing how she was weighing the evidence. Also, Water Watch raises the issue of whether or not ALJ Webster considered the whole record. That argument really comes down to a concern that ALJ Webster didn't list or recite or name all of Water Watch's arguments or every piece of evidence that they referred to in their brief, in their closing arguments. But I just want to point out that that's not what's required in order to show consideration of the whole evidence, or excuse me, the whole record. ORS 183-450 sub 5 requires consideration of the whole record. It does not require that an administrative law judge actually detail all of the specific pieces of evidence or arguments that were made by the parties in order to show that they have considered the whole record. And in fact, there's if you will, a contravening requirement in statute, which is that the ALJ is required to provide a concise statement of the underlying facts. And so that is what ALJ Webster did. She provided 55 concise statements of fact, and she did also support her analysis with an opinion, which is also provided for in the statutes related to final orders. But again, the fact that she didn't recite each nuance of Water Watch's argument does not necessarily mean that she didn't consider the whole record. She presided over the whole hearing. She admitted evidence. She reviewed all of the parties' filings. She did consider the whole record. I just want to briefly also talk about the forfeiture issue or partial forfeiture issue. And I think ALJ Webster actually does a good job of addressing this in her proposed order as well. And she really explains, I think, an answer to the question, Commissioner Newman, you were asking, that Water Watch did not establish any portion or acreage within the place of use that had not been used, that the water right had not been applied to or not been irrigated for 5 successive years. The partial forfeiture issue wasn't raised by Water Watch until we got to the closing arguments. So it feels like a little bit of an afterthought, which may explain part of the reason why there isn't evidence in the record, but there just isn't evidence in the record to support a partial forfeiture argument. And that is exactly what ALJ Webster said, that Water Watch had not established that any portion or acreage within the place of use was not irrigated. And again, I do think that is what Water Watch was saying earlier, that really wasn't what they were trying to prove in the case. They were trying to prove complete non-use. So again, I want to leave at least 2 minutes for questions. I guess I would say that to the extent that you guys do look at any changes to the proposed order, there were just 3 areas where we noted that it would be helpful to clarify some citations. Those were in our paragraphs 9, 12, and 25. And so I just wanted to mention that real quickly. But in summary, I do think that Administrative Law Judge, her proposed order does meet the statutory requirements for the analysis. She weighed the evidence. She determined that the evidence that Water Watch had presented was not sufficient to show that there had been absolutely no use or no irrigation for 5 successive years. And she found the evidence from 3 witnesses, arguably 4, saying that there had been irrigation in 2008 and 2009 to be more weighty. And that is why she determined that this water right should not be canceled. And she's in good company. There are 2 prior administrative law judges that also have reviewed evidence and taken testimony for the same years that are at issue in this cancellation proceeding. Both of those administrative law judges also found that the water right should not be canceled. And those proposed orders were adopted by this commission as final orders, finding that this water right should not be canceled. So I would say for Mr. Black's sake, this is actually the 3rd time that we have had to go through a cancellation proceeding, or if you count also the forfeiture arguments that we went through during the transfer order in proceedings. In each of those cases, the administrative law judge has found that this water right should not be canceled based upon the evidence in front of them and that there was irrigation. And so we would very much appreciate this commission moving forward, adopting the proposed order as drafted to find, hopefully once and for all, that this water right has not been canceled, is not subject to forfeiture. Thank you.
Thank you so much for that.
I gave you guys 10 seconds.
Yes. Hurry quick,
Sorry.
Commissioner Newman?
You said that water.
Such a good question. You get music to go with it.
That's great.
Whose burden is it to show that there was or was not irrigation of the entire place of use? I mean, I think Ms. Wright said that there had been no response by the Blecks to show specifically how much had been partially irrigated or partially used. And the way you characterized it just now is that Water Watch had not demonstrated non-use of the whole part or the acres that had or hadn't been irrigated. So whose job is that? Whose burden is that?
Well, it's a preponderance of evidence standard. And the issues in this case, this is outlined at the first part of on page 3. The issue is not partial failure, but whether there was a failure to use the water right, or not partial forfeiture, sorry, but whether there was failure to use the water right evidenced by the certificate. So the issue in the hearing was whether or not there had been full forfeiture or not. At the hearing, the way that this standard works is that Water Watch bears the burden to show that there was forfeiture. And the administrative law judge, the administrative law judge set this out also in her earlier rulings. And and the Blecks could then show, basically with rebuttal evidence, that there was not forfeiture. And so the burden first is upon Water Watch to show that there was forfeiture, partial or full. And then the Blex can provide contravening evidence, if you will, that there was irrigation, and they did. That was the testimony that ALJ Webster ultimately relied on to find that there was irrigation and that there was not a forfeiture.
And you reminded us of the clear and convincing requirement to overturn a finding of historical fact by the
Right.
ALJ. And then you said that she made findings that there was irrigation in 2008, 2009. What did she make a finding that the entire place of use was irrigated, or that there was at least some activity during that time? And I guess the sub point there is also, how would you respond to what Ms. Wright said about Mr. Smith's testimony not necessarily establishing irrigation use of water during that time?
Okay, so the first, well, I'll take the second question first.
Okay.
And I don't know to what extent you guys go back and read everything, but Mr. Smith definitely testified that he irrigated the place of use from Graves Creek, and that testimony was supported by other witnesses. I know that Water Watch reads that differently, but that is the testimony that he provided, and that is the testimony that ALJ Webster on page 24 talks about. Mr. Smith testified that he diverted water from Graves Creek to irrigate the place of use in the spring of 2008 and 2009. And so that, I think, is the answer to your first question. And the issue that, as I understood, the issue that Water Watch had raised in their exceptions was whether or not that testimony was reliable as hearsay. It's a little different than what they argue today. So the exceptions, I think, were focused on whether or not that was hearsay, and that was addressed in footnote 37. I realize I'm way over time. Do you want me to also answer your other question?
That's sufficient. Thank
Yeah.
you.
Okay.
Thank you.
Okay.
Appreciate it.
Okay.
All right, thank
Thank
you
you.
for your time and testimony. At this point, the commission is going to recess to an exempt session pursuant to ORS. Stopping.
In our for a minute. Extra.
Oh, thank you, Vice Chair Smitherman. For the record, this is Sarah Rowe, the DOJ AUG assigned to this case. And this whole process is supposed to emphasize fairness and notice for equal participation. So I can't say it's a firm legal finding that Water Watch should get additional minutes, but it is my recommendation to just.
Absolutely. Yes. Please come back up, Water Watch. Reset the clock for 4 minutes. 3.
I guess we could start by asking if there are any additional questions of us.
Are there any questions for Water Watch at this point? No, we don't have any additional questions.
Okay, well, I would just elaborate then that, another issue with the ALJ's application of the law here is that in the cancellation proceeding, Mr. Bleck testified that he did not think that application of water after May was a beneficial use. It would not grow the crops. So that this explained why essentially on the aerial photos and the NDVI analysis and so forth, you could never see any greening beyond the wettest months of the irrigation season, which is April and May. So in that case, if you look at the forfeiture statute ORS 54610, which says that beneficial use shall be the basis, the measure, and the limit of all rights to use water in the state and that whenever the holder of a perfected and developed water right ceases or fails to use all or part of the water appropriated, forfeiture arises. That also, we believe, gives rise to partial forfeiture here because of the testimony by the water right holder that water use in 5 months of the irrigation season, June through October, is not a beneficial use. So I just want to emphasize that point. Also want to emphasize that, in terms of whether there was infrastructure here to divert the water, we had testimony of a neighbor who lived right across the creek from the point of diversion and had a beach. They called it the Martin Family Beach. They hung out on Grave Creek during the summer, family gatherings, etc. There was not a point of diversion installed there, contrary to the testimony. So these are the kinds of problems we have. And if you look at the testimony of Jack Smith, Daryl Badger, and Bob Robertson, who the ALJ relies upon here, you had one person saying, we were irrigating all year long except the dead of winter. And then another person testifying, we only irrigated 1 month out of the year. You had one person testifying they were using multiple unlawful PODs on Grave Creek. Another one saying, we just used one. You also had Jack Smith testifying that they had dug 30 100 by 100 foot mining exploration pits on the property, whereas you had Bob Robertson saying, I was on the property all the time and there wasn't any mining activity happening. So these are the kinds of inconsistencies that we weren't necessarily implying an intent to deceive, but you look at that testimony together and it's just not reliable. It can't all be true at once. And so it therefore, I think, cannot establish that irrigation actually occurred here. Thank you.
Thank you. I think it's a great feature to add to our meetings.
I wouldn't stop.
Thank you. So at this point, go back to script. At this point, the commission is going to recess to an exempt session pursuant to ORS 192-691B. The public meetings law does not apply to deliberations of state agencies in contested case hearings under ORS Chapter 183. The commission is now recessing the public meeting so that it may consider the record in the matter of the proposed cancellation of Water Right Certificate 3943. Sarah Rowe, Assistant Attorney General, Oregon Department of Justice, will present the administrative law judge's proposed order and the parties' exceptions. The commission will be asked to consider 1, whether to grant or deny the exceptions, or 2, whether to approve issuance of a final order. The commission will deliberate and will then reconvene the public meeting to vote on these decisions. We will be in deliberations for approximately 1 hour and will reconvene about 9:30, 9:45. We are going off of the record now. Thank you, and we'll be back soon. I need to remind myself of my own recommendation, push the button. We are going to reconvene our meeting. We are back on the record in the contested case hearing for the purpose of taking a vote on the final order. So I will move that the commission deny in part the exceptions of Water Watch and issue a final order that is consistent with the ALJ's proposed order in whole, except for the technical corrections pertaining to finding of fact 13, 32, footnote 11, and 16. Do we have a second? Okay, we have a motion and a second. We will now take a vote. Commissioner Mall,
Yes.
Commissioner Kihara,
Yes.
Commissioner Newman,
Yes.
Commissioner Lee. Yes. Commissioner Wolf,
Yes.
and I also vote yes. Motion passes. So we do anticipate that a final order is going to the parties in a few weeks. I'm going to close the record in the contested case now, and we will not be accepting any more comments related to this case at this time. We will now take a break and then we'll resume with our next agenda item after we come back in about 15 minutes. So at 10 o'clock, we'll resume our meeting. Thank you. Everyone, welcome back. We will move forward with agenda item H, water right related rulemaking.
I think the microphone is on now. Yes? Okay. Good morning. For the record, my name is Raquel Rancier. I'm the Deputy Director of Strategy and Administration, and I actually invited someone who is not on the agenda to join us, and she was in the building and has been a critical part of this team. And so I'm going to hand it over to my co-sponsor who has a more formal introduction, and knowing that we'll all get our names on the record here.
Absolutely. Thank you, Raquel. Good morning, Vice Chair Smitherman, members of the commission. My name is Katie Ratcliffe. I'm the Water Rights Services Division Administrator and a co-sponsor for the 2025-26 Water Rights Rulemaking. Joined here by Raquel Rancier, fellow co-sponsor of this rulemaking and Deputy Director of Strategy and Administration. We're also joined today by our rules coordinator, she's a water policy analyst, and our tribal liaison, Laura Hart, and then Lisa Jaramillo, the section manager for the transfer and conservation section. Can everybody hear us okay, by the way? Wonderful, thank you. So let's show the slides if we can.
I thought you were sharing.
Oh, I haven't done it before. Happy to. Yeah. This rulemaking supports actions 10F and 11B from the Integrated Water Resources Strategy, which are to strengthen and improve water quantity and water quality programs and develop additional in-stream protections. This rulemaking supports these actions by including rules intended to improve water right processing timelines and updating our rules related to in-stream water right applications. Let's get into the need for this rulemaking. The department has heard a clear call to action from water law experts, customer feedback, in the recent passage of bipartisan process improvement legislation from the Legislative Budget Committee, and a signing letter from Governor Kotek, and from internal staff. This call to action catalyzes a recognized need to streamline and modernize water right transaction and contested case processes, to reduce processing times, minimize future backlogs, ensure a clear and consistent process, and provide timely and informed decisions while providing due process. Improving water right transaction processes is a four-legged stool. Our authorities and many of our procedures derive from statutes and rules, which are modified through legislation and through rulemaking. The legislature made substantial changes to water right transaction processes this past session, and many of those changes include streamlining to our processes. However, to maximize improvements to our processes and really meet this call to action, we need to utilize all the tools available to us. That includes making additional strides through internal improvements which don't require regulatory change, efficiently using the resources allocated to us to run our programs, and critically, rulemaking. To meet the expectations set for the agency, we need to not only conduct rulemaking to address recent and past legislative changes, but also to enable us to make policy and process improvements, create consistent processes where we can, and take care of basic housekeeping of the rules. Before we discuss the two major pieces of legislation that have broad implications for our rules, I'll briefly address the third. Senate Bill 1154 impacts our Division 310 rules, which are rules for new water right applications. The Senate bill streamlines the public interest review of groundwater applications in a groundwater quality area that would consolidate drinking water wells into a public water system. The intent is to help address water quality issues faced by exempt wells in those areas. Getting into the two pieces of legislation with broader impacts on our rules, we'll start first with House Bill 3544 pertaining to contested cases. The effective date of this bill is coming up very rapidly. That's January 1st of 2026. It particularly impacts Division 2, but it does impact our other rule divisions. So in summary, the House bill establishes uniform protest and hearing requirements for many water right transaction processes with the intent of improving consistency, transparency, and efficiency. It directs WRD to establish a default hearing schedule for contested cases so that we can complete the process of a hearing within 180 days of referral. It establishes preferences for oral testimony and remote hearings. And here's something that's going to be reflected in a lot of what looks like red line in the rules. We're now going to have a default from PFO to FO if no protest is received. And so how that's going to work is that if a protest period closes on a proposed final order and no protest is received, then 33 days after that, if we haven't issued a superseding final or a superseding proposed order, the proposed final order will become final order by default. So that will be reflected in a lot of edits to the rules because procedurally we need to make sure that everything in the PFO is necessary so that when it becomes FO by default, if that's what happens, it contains all the necessary information. The bill allows for assignment of a settlement judge if the parties are willing to resolve cases in 60 days. So to keep things out of hearing if possible, if folks are willing to settle. It establishes requirements to request party status and streamlines that process. It establishes standards for what must be included in a protest and requires a protest to raise all issues. Finally, it clarifies that a hearing is not required if a protest is settled, withdrawn, or the protestant defaults, say they don't show up. The second piece of legislation with broader impacts on our rules is House Bill 3342 pertaining to water right transactions. The implementation date for this one, also coming up quite rapidly, is April 1st of 2026. This drives the timeline for our rulemaking. The House bill allows the department to send some types of documents electronically instead of through the postal service, utilize the weekly public notice in lieu of newspaper notice with some exceptions, and collect credit and debit card processing fees. The House bill also changes the process for withdrawing a water source from appropriation so that can occur by rule rather than by commission order. That's a technical fix. It requires us to return applications and refund the relevant portion of fees if a new water right application requests to appropriate water from a source that is designated as a critical groundwater area, subject to restrictions on that specific purpose. For example, it is not classified to include that use. or it's otherwise withdrawn from appropriation. So the example I tend to use with folks is Multnomah Falls, ORS 538 withdrawn area. That's not going to be available for appropriation. So we don't want to waste people's time by having an application come in for something we absolutely have no chance of approving. And the legislation addresses that. The House bill also creates phased application processing as well as phased fee payment in some circumstances. For new water right applications and transfer applications, it requires the applicants to affirmatively state after initial review issuance that they want to continue to proceed with the process. So there's three main documents in the process. We're making the names similar between transfers and new water right applications. So we'll use the new terminology here. Initial review is the first major document that the department issues, and it contains our preliminary determinations at the staff level of what we're seeing with the application and how it, based on the information available at that time, it seems to comport or not comport with the regulatory requirements. Then there's the proposed final order, which is a higher level of review and may contain additional information that comes in between initial review and proposed final order. And then there's the final order, which is, conclusive. So at this time, we have folks who will submit initial review, or they'll receive their initial reviews. Maybe it's unfavorable. Maybe they don't actually care to continue with the process, but there's nothing in the process that requires them to say, I still want to proceed. And so staff are needing to continue with the review all the way through final order. The legislation changes that. They need to let us know that they affirmatively want to proceed. For new water right applications, there's also phased fee payment. And so there's an initial fee we collect up front to get folks through the initial review stage. And then at that point, if they want to proceed, they need to pay additional monies to continue. But if we don't receive affirmative confirmation they want to proceed or the remaining fees, we close the file and we take no further action. Finally, the House bill places limitations on extensions, which I will discuss when we get to the Division 315 rules. Let's get into the rulemaking process. We understand this rulemaking is large. We have 18 rule divisions that we've opened, but we're confident that we need to make these changes in order to address the call to action and set water right transaction processes up for success in a way that will benefit applicants, WRD, and the public. Developing the rules has been a thoughtful and thorough effort involving many experts. Subject matter experts for each water right transaction type have worked very closely with management to develop the rules and to revise those rules following rulemaking advisory committee feedback. Our rules coordinator and our deputy director of strategy and administration have been involved on a daily basis, and I am personally very grateful for them. We have also worked closely with Department of Justice on legal questions and rule phrasing. We have also worked with other experts throughout the agency, especially the Technical Services Division and the Field Services Division. In addition to the hard and diligent work of the folks within WRD, we have really benefited from our state agency partners providing feedback. And so that includes Oregon Department of Fish and Wildlife, Oregon Department of Environmental Quality, the Office of Administrative Hearings, which oversees contested cases, and Department of Land Conservation and Development. While some of the changes requested by state agency folks who commented on our process were determined to be out of scope for this rulemaking, I just want to say that their input on changes we are requesting to make has really made this a stronger, more defensible, and created more practical language. Laura will now speak to external engagement and the rest of the rulemaking process.
I'll have to ask you to thumb through that.
Got it.
Can you guys hear me? Okay.
Okay, is
Got
that
it.
better? Okay. I talk kind of loud, so, I just have a handful of slides about the process, focusing primarily on the Rules Advisory Committee and how we've gone through the iterations in terms of updating our rules. This is our RAC roster. It reflects a diverse array of entities who represent folks that are likely to have an interest or are likely to be impacted by our proposed rulemaking. We cast the net pretty widely, starting in early August, polled for interest as well as availability to attend RAC meetings, noting that we would be
timing those meetings to begin in mid-September and running through into November, perhaps. We had a great response. Virtually everybody accepted the invitation. We did invite all of Oregon's 9 federally recognized tribes, and we had 2 representatives accept that invitation as well. Many of the folks on this RAC were involved in the 2025 legislative session, so they have that background. And also because we were including Division 77 in this process, we had undergone I think 2 to 3 previous RAC efforts relating to Division 77. So we took a look at the rosters for those previous efforts and went ahead and filled in any gaps that we had to make sure those folks were involved as well. Hold on, just a couple more points. Let's see. Yeah, so as I said, we had near perfect attendance. I think every meeting, it was either everybody was there or maybe one person wasn't there. So in spite of the schedule and the volume of work, it was just a, very active RAC, very dedicated, lots of expertise, very engaging conversation, very civil conversation. And I think we'll say this more than once, but we're extremely grateful for the input of the RAC and all the hard work they put into this rulemaking. Next slide. In addition to inviting all of the 9 Oregon tribes to participate in the RAC process, we also sent out a formal letter inviting government-to-government consultation and/or informal engagement on the rulemaking. That letter went out before we started any of the RAC meetings. Again, 2 tribes, so Confederated Tribes of Grand Ronde and Confederated Tribes of Umatilla Indian Reservation, they had representatives on our RAC. The Confederated Tribes of Kusalo, Umpqua, and Siskiyou Indians, they requested a briefing from the director's office, and we provided that. And Klamath Tribes requested a consultation, and Director Gall provided that. We also continue to give updates during the quarterly LCIS Natural Resources Work Group meetings and the Cultural Resources Cluster meetings. Those are more at the staff-to-staff level and are more informal. But we continue to extend that invitation to engage in any manner that the tribes wish, and recognizing that's an open invitation until the rules are adopted. Okay, so next slide. This is our meeting schedule. So this will give you an idea of the pace we were working at and sort of the volume. As we noted earlier, 18 divisions. I think we estimate about 200 rules across those divisions that are either being amended, adopted, or repealed. The first 7 meetings focused primarily on the first draft, so our initial proposal across these divisions. October 29th, the AM and PM there is to reflect that we had a morning session and an afternoon session. All of these RAC meetings were 3 to 4 hour blocks at times, so not full days. And then in early October, it was pretty obvious we were going to need to add some more RAC meetings so that we could come back to the RAC and share revisions that we were making to our proposed rules that reflected their input. So we added the October 31st meeting that was focused just on Division 2. That was a virtual meeting. And then we added the 2 November meetings to revisit some specific issues in those divisions that we've denoted there. We also reviewed the statements that are required to be submitted as part of the notice of proposed rulemaking. So there's a statement of need, there's a statement of racial equity impacts, and a statement of fiscal and economic impacts. It includes cost of compliance. So we got into those materials later on in the process, although I will note that economic issues came up, throughout the course of the rulemaking, and we made note of that. see, the other thing I want to note is, so all these meetings were hybrid. They were noticed. They were open to the public. We offered public comment opportunities at every RAC meeting. We drafted meeting summaries that included tables that track specific rule. Specific rule revisions in response to input. We also collected written input from the RAC as well as members of the public. Go on to this one. This is an example of how we tracked the input that we received. And this was for the benefit of the RAC primarily, so they could understand, when they raised an issue, either orally and writing on a specific rule, we would track that issue. So here I have an excerpt just from Division 300. This is what we would call our rule revision tracker. We created this there was a unique one for each of the 18 divisions. And we would note the issue, we would note what our response was, and then how we addressed our response, whether we made a change or did not feel the need to make the change. And these revision trackers are all available on the website. Now, we did have a request from the RAC to create sort of a roadmap. So if you go to the next slide, that would help them navigate where to find all the materials. Because as you can imagine, we have the 18 divisions. Each of those divisions at least has gone through 2 versions, except for Division 2, which we've had 3 versions of that one at this point. So we created a roadmap, and this is just an excerpt, but it's a single table and it has 18 rows, one for each of the divisions. And it just depicts the versions of the draft rules, the dates they were received. And then, so that would be the second column. And then the third column, it's similar. It's the revised version as well as the tracker. And the underlines are hyperlinks. So folks can go into this table, just click on the hyperlink. It'll take them right to the document. So this is something we created for the RAC, but we put it on the website. It's part of the RAC 9 materials, in case folks want to take a look at that. And we got a positive response from the RAC members for doing that. So and then one more slide, I think. Okay, and so this is our rulemaking timeline. So in the end, we had 10 RAC meetings, September, October, November. We are targeting the January 2nd Oregon Bulletin. So that's the next bulletin. So that means we need to get our filing in before the holidays. So staff are working hard on that now. We accepted RAC input and public input on the last couple of meetings through December 5th. So we had input coming in through December 5th. So since then, we've been working hard to address those comments and update those trackers, which we'll also provide to the RAC members and post online. We're looking at the last week in January. I think currently we're planning 2 hybrid hearings, one in Salem and one in Bend. That may change, but I think that's our current plan. The last day of public comment, we've scheduled that for February 6th. So it's slightly more than 30 days. That takes us through the Friday of that week. We'll review the public comments February and March. I think the plan is for the February commission meeting that will give you kind of a sneak peek at, some of the public input that we received. So you kind of know, what we're hearing on our proposal. And then we're targeting March 19th for adoption, if all goes well. Also, that the rules will go into effect by April 1. Nobody has questions on process. I'm going to turn it over to Raquel, I think, right?
Go ahead, Commissioner Mull. No, I was just turning on my mic.
It's not that, so I might as well ask. I actually have 2. One, this is all wonderfully fast. What happens if in public comments you get some sort of not deal breaker, but but oh, wow, that's much more complicated than we thought. Are you anticipating that you might have to pull some pieces out? I'm assuming that you don't have to solve them all to get the other ones to move forward. And has there been anything so far that you're a little bit touchy, like, we're not sure how this is gonna go?
Uh, Commissioners, thank you for that question. And so, yes, we do believe that will happen. And one of the things as we go through this process that I've told RAC members, because it is an aggressive schedule, we know it's an aggressive schedule. And so we have told RAC members, we know that some of them may need to provide feedback during the comment period, right? So many people that have participated, some of them have not been able to provide additional follow-up comment to us. And that's okay. I've told them that's okay, right? We know it is an aggressive schedule. We know there's reasons for the aggressive schedule that we do have. And so I do think that we will see some of those. I also think that folks have raised, for the most part, the big issues. We will outline some of them, but there are some issues that they've already raised to date. And so even if they haven't necessarily submitted a comment, because we did step through at least once, right, the details of these rules in detail, I think that has given us a good sense of some of the areas where there may be concerns, there may need to be additional refinements. And I assure you, we are continuing to work based on the feedback we received. This team here has been working really hard to address those. And I think you can see that if you go online, that every comment we've received, we've looked at, and we've either said, we're going to address it, or not going to address it, here's why. Or I'm going to put a third category in there that's still part of that, we're not going to address it, here's why. This is out of scope. Because it is a big scope and there are some new issues that are being introduced that we just don't have the time and capacity to deal with, and we have to say no at some point on some of these things. So I do expect we will see that.
Process-wise, you don't have to stop the whole train because you're taking a few cars out.
Yes, Chair, Commissioners, that is correct. We can pull things out. I think where it gets more concerning is if you try to put new things in after the, notice has gone out. That becomes more tricky, particularly if it is not reflected well in the notice.
Okay. And then the other processing question, in the material to us, you described a backlog of 2,500 applications. Have you all done any kind of projection on what the catch-up period might be or what your goal is for this, the impacts of all of these changes?
I'll help with that. Thank you, Vice Chair Smithman, Commissioner Mull. We can't easily quantify that, but I will say that, so I want to also add to your, our response to your previous question, which is if we were to take some things out that maybe are causing some concern from folks, but that we believe are necessary to really aggressively address some of these challenges and the call to action from across the board to improve, we risk undermining the goal. And so I do want to be careful about that. So there's some things where folks have said, hey, you thought this was maybe not a big deal, but we think it's a really big deal. And we kind of do a cost benefit assessment. We say, okay, you know what, relative to the benefit we think we'd get from it, there'd be some streamlining benefit. But the concerns are so great that maybe when you do the analysis, it's just worth removing that. There are going to be other things, I presume, where folks say, we really don't like this, but when we're looking at what's needed to get our backlog down and really have better customer service and address these concerns coming from the legislature, the governor's office, internal staff, the folks in the water user community, the public, we might need to keep some of those things in. So that's not a quantified answer, but the intent when staff were working through all of these things was to say, what have the roadblocks really been? And how do we address that through rulemaking if it is a rulemaking item? And if it isn't, we've got a whole other implementation plan that we're working on for non-rulemaking items to really hit that part of the four-legged stool as well.
Awesome. Sounds like great use of discretion. Thanks.
Commissioner Lee? Yes.
Thank you for the presentation. I happened to listen into the last two RAC meetings to make myself more familiar with the issues. And it seemed like there was some feeling among the RAC members that maybe for this first rulemaking, it should be cut back to what was required by the statutes and then to allow more time to do the rest. I'm not sure how that could be done, but have you thought about that more since that was mentioned?
Sure. Vice Chair Smithman, Commissioner Lee, thank you for the question. We absolutely have been having internal conversations about that. And of course, folks within the RAC have also reached out to the agency and had additional discussions with us. So one of the things that I think is important to know is that it's really all integrated, right? So we can have one paragraph, for example, that addresses what occurs at the time of IR issuance. And some of that is going to include statutory implementation, and some of that is going to include process improvement. And so disentangling even a sentence and trying to break it out, that would take us pretty much as much time as it would to just get through the rest of this process. And with our goal of publishing notice on January 2nd, breaking apart all those pieces right now may not be achievable. Another concept would be if we somehow still did that, which again would be a little challenging with this timeline, then that would extend out the rulemaking process, and there's an opportunity cost to that. So as Director Gold has said before, we're going a little slow to go fast. And part of that, at least in my mind, is that this has been an enormous resource draw on the agency and especially WRSD, or I'm sorry, the Water Rights Services Division. And so we are continuing to process applications. We are continuing to respond to customer inquiries. We're continuing to deal with the things that are part of our job, but we can't give as much attention to all those things as we would normally. And so extending out the rulemaking to kind of bifurcate it, the cost there is undermining the goal, in my own personal opinion, of really addressing these backlogs and moving quickly and really trying to address the concerns that people have raised with a lot of urgency.
Chair Smitherman, commissioners, I think what we have told folks is really tell us what are the big issues that are of concern. We can evaluate that. There are some items that are very clearly needed updates that just conform to statute. For example, forfeiture, when we talk about it, is the one that everyone that has been following this process has been hearing it ad nauseum from me, because we have in the rules in terms of the list of rebuttals, I think it's like A through E or some, don't quote me on the exact lettering, but A through E versus A through L or A through N, I think it is. And that's a problem, right? And we have to go into those rules anyways. We should be fixing that. So when I hear just only do 2025 legislation while we're in a rule that clearly does not even match the statute, I think that, becomes a concern. What we hear from Katie here is that Katie's not able to work on moving, water right transactions forward because she's spending her time on the rules, right? And we know that's occurring. And we then need to be able to show progress when this effort is through, right? So I think these are the things that just we have to be weighing and balancing. And that's why I really am urging folks to tell us what are the big issues. I know there's concerns that we're going to miss maybe some little details, right, that will have an impact. And then I think in that case, we will have to be open to fixing those issues down the line, right? So I appreciate the questions because they are what we're hearing. And I think no one understands the mass workload more than all of these folks that are sitting up here. So I do empathize with the folks that are concerned on that front, because we are experiencing it as well. But as we've noted, we've got a lot of folks working on this. And at the end of the day, we're getting quite a bit of pressure from multiple, avenues about these programs here. Should we move forward?
I believe we have one more question, Commissioner Newman.
Just a comment. I appreciate that this is a massive undertaking and I really appreciate your work on it. And I am happy to see so many RAC meetings and a good broad representation on the RAC. So keep up the good work.
Okay, I think it is now turned over to me. So we're going to provide you with a very high level overview of what we're working on. And so these are the 18 rule divisions that are impacted. And as we go through these, and what I think you're hearing based on the legislation is that a lot of this is about the process for processing water right transactions, right? So you'll see a lot about initial reviews, proposed final orders, and the whole process around processing water right transactions. This includes policy. I want to be clear. It's not only just procedural, but it is very procedure heavy. The other piece that I'd like to just give you some context around is that I've ordered the slides intentionally to not follow the numbers of the divisions, right? So you'll see them being out of order. And that's intentional because we've ordered it so that the first couple divisions are ones that apply to almost all of the rule divisions that we're amending. So we'll start with those. There's a couple of them. And then we will go into the life cycle of a water right, essentially. We try to as closely as possible. So you'll see new water right permits come up first. Then we'll talk about extensions of a permit, permit amendments, right? So that's if you want to make a change to a permit. And then we'll talk about proving up and we'll also get into extensions. And then we go into the changing of water rights and cancellation. And then hydro is at the end kind of hanging out there because it's a little different. So I just wanted to give you that context of what we're talking about. All of these are pertaining, though, to different water right transactions that go through the Water Rights Services Division. The other piece that I wanted to give you some context is that you'll see there's blue on some of the slides. Blue falls into these buckets, essentially. We wanted to make sure that folks kind of knew where the 2025 legislation was coming in. Katie just gave an excellent explanation of the 2025 legislation. In the interest of time and not to bore you, we are going to not repeat those things. You'll also see on some of the slides rule clarity. That is essentially bullet one, right? Where we have a number of these items that are in there that probably not the details we don't need to keep reiterating. So the ones in bold here are associated with the legislation. I'm not going to go into detail on that, but I just wanted to make sure that folks were aware of that. The other item that has come up quite a bit is land use. And we've heard significant concerns, so remembering what I said about there's some issues that folks have raised saying, hey, this one's a big one. This is one of those. And we are, for the most part, reverting back to the existing language. You all know that we will be having a joint commission meeting with DLCD and LCDC, Land Conservation Development Commission, and the Department of Land Conservation Development. I think I got that right on the spot there. And we'll have that in February. Meanwhile, we have staff that are working on updating our state agency coordination plan. So I just want to acknowledge land use is something that's of concern. We've heard from various folks about that. And so there's just one change that I think we're looking to make. We haven't made final decisions on that, but for the most part, we're leaving that alone. So I'm going to then move us to the next one, which I'll also note, you'll sometimes see green on the screen. And the green is kind of an indication that we're not probably going to talk about that if you see it. So on this screen, you can tell it's up there. But so with that, Division 2. We're going to start with Division 2 because this one touches all the different divisions. This one was also explained with detail for the most part by Katie. I just want to touch on this piece around the default hearing schedule and completion in 180 days of a hearing. So from referral to completion of the hearing, 180 days. And so that is driving some of these changes, one piece of it. Also driving some of these changes is we have over 200 protests. I don't like talking about backlogs. This is an area where I believe backlog is the appropriate word. We have some of those that have been pending since the 90s. And we often hear, people saying like, hey, we need to make sure we do thorough hearings. That is true. And they talk about due process. I also want to note, though, that we think due process also means a timely hearing, right? And so part of the changes that we are making is driven because of that. There's a significant number of protests. So the quantity, the complexity, as well as this 180-day schedule that we need to meet now for the most part. There are exceptions to that, but that's what's driving some of these changes here. And so with that, I do want to acknowledge the hard work of Jesse Ratcliffe, who's with the Department of Justice, who represents WRD. And him and I have worked so much together on these things as of late, along with Will Davidson, who is one of our staff here. And so put in significant time on a lot of these divisions here. And so with this, there's a couple items I did want to just raise. And, I'm realizing there's no clock here, so I don't know how we're doing on time.
21 minutes.
Okay. So I think we're going to be ahead of schedule today. So we're going to be a little slower in this presentation than we initially had scheduled. So with that, we are proposing the ability for the department to consolidate or bifurcate hearings prior to referral. This one has received a lot of feedback. We are also proposing and part of that feedback, I'll just note, is folks wanting to be able to submit concerns, arguments. I don't know what the legal term is for that, but to be able to say, we don't want you to do that, and to want it to go through the administrative law judge, ALJ. And from our standpoint, that's not necessarily efficient, right? Part of this is an efficiency measure to group like cases. So that's one of the items that we're hearing about. The other one is discovery that we're hearing some interest in. And so within this rule, we're proposing to limit admissions. At the moment, it's limited to 0. Interrogatories, we're proposing to set now at 10. We originally proposed 5, but as a result of the feedback, we've raised it. And then there's a provision in here that essentially says at some point, once you get to, we originally started at 25, I think it's now up to 30 hours of staff time for discovery, it will need to then become a public records request for the rest of those things. And that does include fees. The reason around that is in part because, again, it goes to that if we're doing all of our time only on one case, right, then we're not providing other folks with their due process. So that is just, and if you think about 30 hours, 200 contested cases, you can see how much staff time that would be, and we'd still be processing that for more than a year, a couple of years probably. So we also have put some limits on site visits, and so a number of other things in there. The one thing I will say that we are trying to improve the process and make it so parties can resolve issues as early on before referral. So there's new language around settlement discussions. But we're also trying to drive these forward in a way that can drive case efficiency by providing notice of issues earlier in the process before referral, and also providing our file. So you don't have to request discovery. We are going to provide you with a file upfront before we refer. So with that, this one's an important one. So I want to pause just to see if I messed any of that up and if Jesse has anything. Nope, he's saying we're good. Okay. So that's one piece of it. You'll see that throughout. We're not going to repeat more items around that. Chair Smitherman, I believe that is your decision. So
I think as we're going through this, I think it's appropriate to go ahead and ask questions. Go ahead, Commissioner Mall.
I'm gonna ask a question now, so it's on. The 180 days, I'm assuming that's forward going, that you're not going to all of a sudden apply the 180-day guide to the cases that we are already on pause or such.
Chair Smitherman, Commissioner, that is correct. I'm going to be a little more precise with what I mean by that. If we have not referred a case over yet, then this 180 days doesn't apply. After these, well, basically after January 1, I think is how it's written, take cases that go through that are referred over after January 1, they would be under this 180-day requirement. That's how the legislation is written.
Yes, for the record, Jesse Ratcliffe. So the statute, House Bill 3544, envisions the Office of Administrative Hearings and the department working together to come up with a default schedule that would meet that 180-day timeline. That will, of course, be part of the rule package, won't be in effect until April 1st. There is a requirement that becomes effective on January 1st that refers to that 180-day time period. So the department's going to have two tasks here. It's looking for provisions of House Bill 3544 that are essentially kind of self-executing, that are just the law as of January 1st. There's an effectiveness provision in the statute that addresses how to handle those things. And then the statute also says, and you may adopt rules to implement. Those will then kick in as of April 1st. So unfortunately, as with a fair number of things pertaining to this legislation, there are going to be lots of kind of carve outs, hedging, it depends on the circumstances kind of things, but that is the general overview of how that works.
So the implication is it's going to take a lot more bodies to implement this, right?
Mhm.
Staff levels. And so am I reading that right?
Chair Smitherman, Commissioner, no, I don't believe this is going to take more bodies to implement.
Okay.
Yeah. Okay. With that, I will acknowledge that we already don't have sufficient bodies. So I want to be clear, but this is, from our standpoint, going to be more efficient with the existing staff that we have.
Go ahead and continue.
Okay.
Thank you. For the record, again, this is Katie Ratcliffe. Division 300 contains many of the definitions that we use for our water right transaction processes. And as you'll see here again, we've got the blue text indicating we've already covered that in other ways, so I'll highlight the other parts. The 300 updates would remove part of the definition of proposed certificate because a field investigation is not needed in order to issue a proposed certificate. So we pulled out the words field investigation. The Division 300 definitions already apply to a number of other rural divisions, including those for claims of beneficial use, transfer applications, and new water right applications. This rulemaking would expand applicability of those definitions to other rural divisions, specifically Division 382, which are rules for groundwater registration modifications, and Division 385 are rules for district water right transfers. Division 305, you will probably not have heard of this one before because it is a proposed new rural division. We're really excited about this concept because I know I didn't tell you I was going to say this part, Raquel, but we had done our, we call it our CWA Roadshow. So we'd gone around last year talking with folks in the certified water right examiner community. And one of the things that kept coming up as a theme is frustrations about inconsistencies in our rules about different mapping requirements based on the transaction type, or maybe even criteria that they felt that we didn't really need. So we took a really hard look at our requirements to create better consistency and remove requirements we felt we didn't really need. Division 305 is a new rural division that would establish standardized mapping criteria for maps submitted to the Department for Water Right transactions. The intent is to reduce confusion, increase efficiencies by standardizing those criteria in one place. I'll also note that additional specific mapping criteria do come up in other rural divisions, and that's if 305's general criteria that apply to everything does not fully cover what's needed for that water right transaction. So as an example, Division 18, which is our rules for allocation of conserved water, you're going to see in our draft rules a reference to the need to meet the Division 305 general map criteria, and also make sure that the map includes sufficient detail on the location and a description of the facilities and the areas affected by the conservation measures. Division 340, it's titled Water Use Authorizations. Fairly general name there. It's because it covers a variety of topics, but we're going to focus on the rules governing the expedited secondary process for use of stored water. The changes would provide greater clarity on how the department determines that a public comment has raised or identified a public interest issue that merits moving the expedited secondary application out of that expedited review process and into the standard review process. The intent is to provide greater clarity following recent legislation.
And for clarity, that's recent litigation.
Yes, thank you. I've been saying legislation so much this presentation. Thank you, Raquel. Moving into Division 310, our rules for new water right application processing. So think about that chart that Raquel was showing, or the figure showing the different steps in the life cycle of a water right. We're at the beginning. Division 310, rule updates would require notice to a landowner if a water right applicant other than the landowner applies for a water right on the landowner's property in whole or in part. This is a due process requirement to make sure the landowner knows what is being proposed on their own property. If a person is signing on behalf of an entity, such as a corporation, the rules would require that the application contain evidence that that person has the authority to sign on behalf of the entity. The draft rules remove informational requirements that we believe are unnecessary because we have other efficient means of gathering that information. So that's to reduce a burden on the applicants as they prepare their application. The existing new water right application process allows for administrative holds, which if granted, prevent WRD from moving to the next step in the process of issuing a proposed final order during the period of the hold. So after we issue an initial review, if folks want more time to gather data or have conversations, they can request an administrative hold, and that means staff cannot issue a proposed final order. So essentially the applicant has flagged, we don't want you to move forward yet. And the history of this, in some cases, has led to really lengthy timelines in processing. I'll think of one circumstance where an applicant requested 10 administrative holds that span about a 13-year period. Meanwhile, they're holding on to their tentative priority date that is senior to everybody else who has applied since then. So with a history of lengthy periods of time based on requests from the applicants, we're trying to balance giving folks the opportunity to gather more information and have conversations with the need to move forward in the process and be fair to everybody else who's coming in down the line with a junior priority date. So the rule changes would define what a reasonable and necessary hold is. Reasonable and necessary appears in statute and rule, but the rule changes would provide further definition about what that means. Division 315. So we're talking about water right permit extension rules at this point. folks receive their water right permit. They have a certain period of time as specified in the permit within which to develop that water right, and then come in and apply for a claim of beneficial use showing that they've perfected that water right. If they need more time, they apply for an extension of time. The House bill, specifically 3342, set limitations on the number and length of extensions of time. For context, under current rules, some non-municipal applicants have been able to extend their permit development windows from the 5 years in the permit to, in some cases, 20 or more years by applying for multiple extension of time applications. And so again, that's a situation where someone is holding on to a senior priority date, but not fully developing out their water right within the timeline intended by the permit. But again, we do have that process that is available to folks right now. The House bill, as I indicated, sets restrictions. And so what I'm about to describe here, it's complicated. I do want to also let you know, if it doesn't sink in the first time, that's been the case for all of us, but it's also not discretionary, right? So this is strictly implementation, but we thought it was important for the commission to understand this context because it's a big change. So first, under the House bill, extension of time applications for municipal water use permits were not impacted. Quasi-municipal use permit extension of time requests received by the department starting April 1st of 26 onwards can only obtain one extension of time for a maximum of 20 years. Group domestic use and group domestic use expanded permits applying for an extension of time, and we receive that extension of time April 1st onwards, could only receive a maximum of one extension for up to 10 years. The legislation created stricter limitations on other types of permits for which an extension of time is sought, such as permits for irrigation, commercial, or nursery use. There's a phased approach here, and this is where it starts to sound complicated. There's wisdom behind what they did, though, in my opinion. So here we've got, I'm going to refer to a couple different groups here. The water rights section, which issues the permit, and then the extension of time group, which looks at extension of time applications. So if the water rights section issued a proposed final order on the permit application prior to April 1st, and the extension of time application is received by the other group on or after April 1st, one extension of a maximum of 2 years may be granted for these other than types of permits. For any extension of time applications currently in our queue and in our queue before April 1st, that we're able to issue a proposed final on the extension of time application, the new restriction won't apply unless or until there's another extension of time application submitted. If we run out of time to issue a proposed final order on any pending extensions in this other than category, the up to 2 year limitation will then apply. For new water right applications that receive a proposed final order on the permit application on or after April 1st. So think of the ones sitting in the first group right now, not sitting in, but in process right now. If they receive a proposed final order on that permit application on or after April 1st, the development timeline will increase from 5 years to 7 years. So they will have more time in their original permit to develop that water right, but no extension of time opportunity will be available.
Chair Smitherman, commissioners, this is a complicated issue. You do not need to understand it fully now. It is in the legislation, right? So this is non-discretionary. When we start talking about all these different things, I suspect we probably need to have something in writing so everyone can retain this. So there will not be a quiz on this item, okay?
Yeah, clarifying question, Commissioner Newman.
Quick clarifying question on that point. Is this one of the things you're getting? I mean, obviously the legislature set these extension timelines. Is this something you're hearing about as a problem? I mean, it looks to me like they solved one problem by offering longer extensions to quasi-municipal, which can be more like the development required for municipal, but no, extending the initial term from 5 to 7 years for other rights, but no extension. Are you getting any comments that that's going to be a problem?
Chair Smitherman, Commissioner, I think we've heard some concerns. I think though everyone has acknowledged that this is nothing the department has control over. This is in the legislation itself. And so that's the decision the legislature made.
Okay, thanks.
Thank you. And then to be clear, all types of permits, extension of time requirements must be met. So even with the more limited extension timelines available, they do need to meet all the criteria to get that extension of time. And so to summarize that big piece right there, the key takeaway is the legislation reduces the number and length of extensions that are available to folks. And so that is a lot of what you'll see in Division 315 is that implementation piece, non-discretionary. There's another item we'd like to highlight, and that's the rules would make clear the department's longstanding practice of denying applications when the permit holder has used water but has failed to demonstrate that they met the fish-related permit conditions that were required to be met before water use began. So that's been on our application form for a long time, but we wanted to make it really clear in the rules that that's the case.
Okay, so for Division 325, this one is going to be brief because so this is assignment of water rate permit. And this one is, we tend to call it split a permit.
Yep.
And so this one is always one that I always wonder, what does this mean exactly? It's our split a permit process where you can take a permit and essentially split it in short. And so a lot of the changes that we're making here, we're not going to go over today because most of this is driven by, as you can see, all of the items in blue. I want to highlight though, the key piece that I think is important is that we are trying to create consistencies between 380, which is our regular transfers, 382, which is the groundwater registration modifications, and this division, because they're all a type of change to a water right. And the more streamlined we can make and consistent we can make those processes, the more efficient we can be. Right now, Lisa, how many processes you have?
Well, I'd say at least 15 different types of transfers.
So you can, yeah, so you can see how easy it would be to get hung up on, well, okay, it's this process. What does this process require? And so that is one of the key reasons that we are trying to create consistency across divisions. That will help staff know what they're supposed to do and have to spend less time trying to sort through what they're supposed to do. That also helps the public understand what the process is as well. So that's what I just wanted to make sure that, we had highlighted in looking at the other pieces. I don't know that we need to talk in more detail about this one today. I want to move to then 320 and 330. This one, we originally only proposed to the RAC to make changes to 320. The current title of 320 is water right permits. And the RAC, there's a number of rule divisions or rule sections that say the exact same thing, and they're in 330. We are not making changes to the other provisions in 330. So we had initially said, we're just going to delete the duplicated language from 320 and not make changes to 330. Well, the RAC rightly so said, well, that's true. And even though all the rule language is the same, the title's different. And so then that got us looking at the titles. And that raised so many more questions because a lot of the items that were mixed between, some of them didn't apply to certificates, some of them didn't apply to permits. And really what it came down to is there was a number of provisions that were really about proving up on a water right. And so we decided to retitle because basically 320 is just a mix mash of random provisions, which may or may not apply to water right permits. And especially if we renumber and move some of the provisions that are in 320 over to 330. That makes 330 be able to be a clean proving up. essentially division. So as much as I didn't want to add another division to this rule, we've been very clear, the other sections within 330, we are not changing at this point in time. We don't have the time, that's out of our scope. That would need more attention, but that is just one of the things that we are doing. So you'll see a lot of changes there and new rules in Division 330. But that is driven by this issue that we couldn't figure out. It just didn't make sense, right? And sometimes when you see that it doesn't make sense, we need to fix it. Okay.
So we're moving now into part of the process where someone is proving up on their water rights. So they're showing they put the water to beneficial use, they've perfected their water right. We have rules for, well, it's the existing title is Certified Water Right Examiner, so the rules do pertain to their role in our processes, but we wanted to make it clear that those rules also apply to preparation of claims of beneficial use. The existing rules already do that, but we've modified the title there to reflect that, or that's the proposal. So the Division 14 rules that we're proposing to change would create clear linkages between those rules and our Division 217 rules. We're not trying to touch those right now, but the Division 217 rules contain requirements for pump testing of non-exempt wells. A pump test is a controlled procedure in which water is withdrawn from a well at a constant rate for a specified period of time, and in which the water level in the well is measured at specified intervals before, during, and after pumping. So under the Division 217 rules, the department cannot process a claim of beneficial use on a groundwater permit until the pump test requirement has been satisfied. However, in Division 14, as it currently is written, there's no requirement to submit that information with the claim of beneficial use. So that leads to inefficiencies, confusion for folks who are submitting their claims of beneficial use about what we actually need to fully process their claim of beneficial use. And then we end up with backlogs when the pump tests cannot be secured. So our folks on the certificates team have to spend quite a bit of time figuring out, can we even process this right now? The rule amendment would require pump test or pump test exemption request be submitted with the claim of beneficial use for groundwater permits in order to address this.
Okay, now we get into the two that are pretty big. Remember when I said we're not going to talk about what's in green, but you're welcome to ask questions. That's why we have Lisa here. There's 380 is I think one of our biggest rule divisions, though I've not verified that. It's long. And so there's a lot of changes in here, and we wanted to be transparent that there's a lot of changes in this rule division. I recognize that this is not the most coherent way to organize a slide. And so this is more of a nod to everyone that is saying, hey, there's a lot going on. To note, there's a lot going on. There's a second slide here, by the way. So this isn't even all of it. But there's a couple pieces that we wanted to make sure that we did highlight. And part of that is that we've heard some feedback on it. We haven't made decisions on what we're going to do. So this may continue to be an issue in the public notice draft. It may not be. I will signal on one of them. I do think there is a direction that I do want to make sure we're at least noting for folks. So the first one here is the process when forfeiture is submitted is part of a transfer protest. I want to acknowledge that this is also part of Division 17, which we have yet to get to, which is forfeiture. No surprise there, because this is about forfeiture, right? And this is probably relevant to some of the things you all were deciding earlier today. But this question really comes up is, what happens when a protest on a transfer brings up forfeiture? And yet our forfeiture rules have specific requirements of what needs to occur when there is a forfeiture proceeding. So we have been trying to figure out a way to make this an efficient process for everyone involved and to reduce that confusion that occurs. I think that on this one, we've done our best. We've asked the RAC to do their best thinking on it. And I want to acknowledge that at some point in time, there still may need to be legislation to really be clear on this issue. We have tried to fix it to the extent that we can within the limits of the current law. And so with that, I do want to check in with Jesse to see if he wants to more fully explain this issue, or if maybe I was sufficient on that one. But I do think since we have Jesse here, it might be worth hearing from him as well.
Yeah, thanks, Raquel, Vice Chair, members of the commission. For the record, Jesse Ratcliffe. So the issue that arises in the transfer process is that ordinarily, if there has been non-use of water for 5 or more years and there's no exemption to forfeiture that's applicable, either the department can initiate or a member of the public can come forward and say, I think there's been non-use here. And there's a fairly clearly defined process of what is supposed to happen from there. There are rulemaking changes needed there to reflect statutory changes that have occurred over the past decades. But otherwise, it's relatively clear what happens. In a transfer context, one of the elements of a transfer is that you're moving a water right that is a water right. If you have a water right certificate, it's presumed that your water right is valid. And that you can go through that process. But we do have these instances where a protest will be received that says, well, actually, I have evidence that this water right is subject to forfeiture for non-use. That poses challenges because we can end up in a situation where there are 2 competing legal proceedings going on, one to try to deal with the transfer and one to try to deal with the forfeiture. The administrative law judge also has an obligation to tackle issues that could pose a barrier to approval of the transfer, and the non-existence of the water right would be one. And so what we're trying to do is acknowledge the reality of the administrative law judge's job, the potential for these 2 competing processes to be going on at once, and try to sort of bring them together, where we have one process that will be moving forward and an explanation of how that process is supposed to occur. That's probably about the level of detail that you're looking for right now. I can answer more questions about that, but this is not theoretical. This is something that the department has come across numerous times over the past decade, and each time it's happened, it's been tremendously lengthy and expensive to try to get through.
I will also note that we do have a current rule on it. And I think it's in the transfers rule, right? And that rule, like some of our rules, doesn't necessarily provide the clear direction that is needed. So we are taking another attempt to do so. So that one is the issue that I think we've heard quite a bit about when it comes to this rule division. And I want to acknowledge is an issue we're trying to fix, right? The other pieces that I'll just note more is just for you all is that we did receive some comments around our clarification of injury and enlargement in terms of there's various different transfers processes in these rules. So we are taking a look at that. We to date have said that we believe injury and enlargement are the criteria for changes to water use and have been seeking to implement that throughout the rules. I know we've received some feedback on that and are taking a look at that. There's also then the associated conditioning of water rights to prevent injury and enlargement. There's been a lot of discussion over the use of the word potential or likely enlargement and whether that word is actually needed. So we've heard some on that as well. The other one that we've heard quite a bit about is the director's discretion to waive a fee, and it's a fish-friendly project, as we call it. There's specific ones in there, and we had, you'll see this one, an allocation of conserved water, which is coming up as well. And under this one, we had proposed to change shall to may, which is what aligns with the statute. We've heard quite a bit about that one. I think we will probably revert back, so we haven't made a final decision. Katie and I haven't talked about that, so we're surprising her on the spot about that. But we have heard quite a bit of feedback on that particular issue, that folks want that certainty that we are going to waive the fee for those fish-friendly projects. So there's a lot on here. A lot of these things I think are very nuanced details, but happy to take any questions on this one, noting there's still another slide on 380. Okay. So remember, I said there's a lot of different processes under transfers. We really appreciate the work Lisa's section does. And there's a particular provision around historical POD changes. And one of the provisions in there, so this basically, if you've had a POD in place for 10 years, you can go through this different process to do a change. And the interesting part about this rule that has caused a lot of discussion actually is that the title says historical POD and POA, so point of appropriation changes. The rest of the rule only talks about surface water like stuff, right? And so we I think had initially proposed to fit the rule to the title, and we've heard a lot that this looks like, wait, this should probably be just limited to surface water. So that one is one that we've, I think we're leaning towards now going in the other direction of limiting to surface water. And so that's one of the ones you'll probably hear about as we go through this process.
I think actually, the existing rule had both point of diversion and point of appropriation, but the title just had point of diversion. I believe that's what it was.
Thank you, Lisa. It was inconsistent. That's what it comes down to. So we're trying to fix that issue. There's a number of other provisions there. Again, not going to cover those. Happy to discuss any of them. The other piece, though, that we are doing is which is the reason for, in retrospect, I kind of wish we would have adopted a new division. So we could at least say Division 380 would be shorter. But a number of pages are being added to this rulemaking because we don't currently have rules governing permit amendments on the books. So remember when we talk about consistency, this is essentially trying to adopt rules for permit amendments that are similar to regular transfers processes, but also acknowledges that there is some distinctions in the statute about what we do when it comes to permit amendments. So that adopts new rules. The other piece there is we have temporary transfers are also addressed in here. Again, a lot of trying to create consistencies. And there's two issues here that I would just identify for you all. One is that we are seeking to adopt new rule to allow temporary transfer renewals. And that is trying to be efficient. So an efficient process there. And the other piece, because we've heard a lot, by the way, from folks about wanting temporary transfers to go super fast. How's that? Faster than they are today, as with all processes. But that's one where it's been a high priority, and there's a new key performance measure on it. The other one, there's a number of items in the rules, and so I just want to flag for this one here, where there is a delegation of authority from the commission in the rule to issue the final order for exceptions to the administrative law judge's proposed order. That one I haven't heard much about, but since you're the commission, I felt like I should highlight it for you all to note that that is in there because we also don't want to hide the ball from you all if you all would like to, retain that. So that is all I was intending to cover today for 380. So I'll pause there and see if there's questions or comments on that front.
Commissioner Lee?
Yes, under temporary transfers, does that exclude the process that irrigation districts use? Is that a separate piece?
Yes, Commissioner Lee, that is it does exclude Division 385 district temporary transfers. We're not touching that.
Chair Smitherman and Commissioner, it's a great question because that is one of the many processes. And the legislation, I think it initially attempted to make changes to some of the district statutes, and they have differences, substantial differences in some of the things, and the legislature removed those provisions. And as such, we, in doing this rulemaking, focused really just on the regular processes. Good. Okay, Division 382. This is groundwater registration modifications. A lot of similarities to some of the changes in Division 380. Not as many. They're more procedural, as you can see from the blue there. But the one that I do want to point out, because fees are always something that we need to make sure we point out, right, when there's a fee increase, is the 2025 legislation that was not covered here, the fee bill that was passed. So when we listed the three pieces of legislation, we didn't actually list this one. And the fee bill increased the maximum that we can charge for a groundwater registration modification. So the cap is set in statute. The actual is set in a rule. And so with that, what we did was we just essentially raised it using the percentages. So for the rule, it says that for a place of use change, it's basically 70% of the max. We did our calculation. And then, so we don't have to keep doing these changes in the future. We can go based off of legislation and what the legislature decides. We're actually making them percentages versus numbers. Right now they're numbers. And then the other piece to that then is for all other ones, currently it goes with the max. And so we would go with the max as well. So that one we wanted to make sure we highlighted. I will note when I say there's changes similar to Division 380, this one has a lot fewer changes than 380. And that's because there's a lot fewer processes that are covered. And so this one's I like this division better because it's shorter and less nuances than what we need to deal with on 380. Moving into Division 77. So as a reminder, Division 77, we previously had a Rules Advisory Committee several years ago. I don't remember what year now. It's been a while. And there was a number of changes discussed on this division. This was when the whole transfer of stored water issue was bubbling, and that it has now been resolved, but mostly resolved. But as a result, the commission, there were some concerns that we hadn't addressed stored water, if I'm remembering correctly, the why it stalled out. And so we had been asked to go and review that. And then then COVID happened, and we also had our only rules person leave the agency. And so we didn't have staffing support. So it kind of got stalled out from that standpoint. So with that, we started with the rule draft that the last RAC left off with, is my understanding, and then made changes based on the legislation, plus some additional modifications, some of which are because we've been hearing the requests for them to get fixed. So one of the items that we have added to the rules, we've heard some comments on this one, is trying to just be clear about where our jurisdiction is, because sometimes folks get nervous that we're going to issue ourselves an in-stream water right to protect water in California, right? And for example, and really OWRD doesn't have jurisdiction to issue a water right in another state. So this is really trying to clarify that we protect water in stream. We partner with other states. For example, there's work being done in the Walla Walla. We're trying to make sure that we're clear about what we do. Washington has some protection of flows on the Walla Walla River as a result of how we protect flows in Oregon, but it is not Oregon that is doing the protection, it's Washington, right? So there's some nuances there that we're trying to make sure we're clear about. The other piece here is for new in-stream water rights. I think it's been over a year, but I don't know what year it was, where the Special Districts Association had approached us with concerns that us and Oregon Department of Fish and Wildlife about concerns about in-stream water rights and how cities receive notice, but special districts don't receive notice of new in-stream water right application filings. We've heard quite a bit on this one. Obviously, the Special Districts Organization would like this to be incorporated. When they had approached us, we had talked with ODFW and they agreed to provide notice to special districts if the Special Districts Association of Oregon provided the list and the contacts to make that an efficient process. We had assured, we received assurance, I guess, and it made it clear is maybe the better way to say it, that, if ODFW didn't do this, this wasn't a ground for, challenging an in-stream water right application. This was something they were doing voluntarily and said we would bring this up when we come back on Division 77 rules. So we have brought it back, and basically, obviously, there's folks that want to have us adopt this. And part of that is they believe it reduces protests by the districts having this notice in advance. The other side of the spectrum says, hey, no one else gets to get notice before a water right filing application, well, except with this, city local government provision that's in the rules. But generally, you wouldn't have that. And, priority dates are important, and, concerns over that. So we're receiving, I think, good feedback from both sides. So this one is another one of those issues where we can certainly see both sides of the coin. I want to move on to, let's see, another provision that I think is important to highlight. Netting, you've seen some of these other pieces and other rules, and that is really, I will note we are trying to address requirements around stored water. So now that has gone through the courts and through all of those other processes. So that is in here as well. One provision there that I do want to point out is this removing what's called the estimated natural annual flow. Did I write that in there correctly? Now I'm looking at
Estimated average.
There we go. I don't think there you go. Don't quiz me on what that means. I just know it's ENAF. And up until this rulemaking, I thought it was ENAF, which is why that is typed that way, because half my brain knew it was right and one knew it was wrong. So I apologize for that mistake. This one we have looked at, and ENAF is still proposed for new in-stream water right applications to be, so it's still in there. It's not being removed. And on the in-stream transfers, leases, and allocation of conserved water side, we're proposing to remove it. And we believe we have the statutory discretion to have that in there for new in-stream water right applications. We believe we don't for in-stream transfers, leases, and ACW. What is ENAF? Which one of you two would like to describe ENAF in short terms, since I can't even tell you what the actual wording is, apparently?
Well, for the record.
Short terms, one sentence.
One sentence. For the record, Katie Ratcliffe, and since this is something that comes up again and again in contested cases, I would normally want to have that paragraph in front of me and just read verbatim, but
maybe it's how do we use it?
Think of the natural system, right? Before consumptive uses, before storage. So looking at that natural system. And so when we receive a request, for example, from Oregon Department of Fish and Wildlife for a in-stream water right at public benefit is for, say, fish, what we're going to be looking at is, are they requesting something that's above the estimated natural average flow? And if so, then what we do is we limit the request, and it's on a month or by half month basis to estimated natural average flow. So we get that information from our surface water hydrology team. But I do want to be clear that the existing rules do contain that restriction and do allow for an exceedance of ENAV if periodic higher flows are necessary for, say, a particular life stage of that species. So there is already the ability to go above ENAV if they demonstrate a need for it.
Okay, that was more than I thought we were going to talk about, but I appreciate that because I recognized in that moment that we needed to make sure we did talk about it a little bit more.
We appreciate it as well.
Yeah. Okay, so moving on, there's in-stream leases. The piece I just wanted to highlight here is we've heard a lot from the districts about, well, and from our own staff. Nobody likes this process. This is one thing we can celebrate, I think, because our staff think this process is unnecessary and burdensome, and so do folks externally. And so we are going to fix it. And essentially, there's written authorizations that the districts need to get from water users. And currently, we require them to submit all of those things up front to us for some processes, and then other processes we don't. And so we're removing it. Lisa?
Yeah, the burden for the temporary in-stream lease is higher than it is for the permanent in-stream transfer. So it's what we're trying to fix.
The other piece, talking about efficiency, so that was one efficiency provision that came up, but the other one is really, we have developed a process. Again, we've heard this from some of the folks that do a lot of in-stream lease renewals, that they would like to have an efficient process for in-stream lease renewals. So we have a new rule on that, thanks to the great thinking of Lisa. There are some limitations on this because the statute does require, what is it, a 21-day period?
Yes.
That's a public comment period. So there's still limitations to how quickly we can do just based on what the statute has. So with that, I'm going to switch to the next slide on in-stream water rights. So these are the two big divisions here. We also have a rule around converting minimum perennial stream flows. There's two basins that we're aware of at the moment that have unconverted minimum perennial stream flows. The one that is often talked about really is the Willamette. And so this rule change does try to make some alignment with the statute. And part of that alignment really is fitting our modern workflows. And the way it points to provisions around issuing a proposed final order, for example. So there's some changes in that one in an attempt to fit into the workflows that we have today. The other piece there that's also a kind of a one-off one in here is around precedence of future uses for multi-purpose projects. So this is essentially when a storage project can get precedence over an in-stream use or water rate. And so this one, again, has some of that language to have the department make the decision, not the commission. And this one might be one of the ones. So when we present to you all, we'll have to be really clear about which ones are discretionary. I can't remember if this one was one, Jesse, I don't know if you remember, that the statute actually says the department is to make the decision. I think this might be that one. But so we will be clearer on that of where you have discretion versus not when we come back around to you all. And it also then continues to align with the water rate processing steps and changing the hearing to a public, or it currently has that there should be a hearing. And we propose to then change that to a public comment period and then issue this as part of the proposed final order. The current process is a little clunky how it's written in the law there.
You guys, any perspective as to why the legislature would make it a firm removal of using authority rather than option?
I need to go back and look at this one, but my recollection in looking at this, well, I want to make sure because we're now into that land of I'm trying to remember what was minimum perennial stream flows versus what is precedence of future uses. So short of printing out the current statute, I need to refresh my memory on that. So I apologize for that. But I think when we were looking at it, it seemed like it was supposed to, and that's how we changed the rule, is currently it has like this process that's unclear how it really fits into the water right process. And I think in our opinion, but and so the way we've reorganized it is that the precedence of use, you can, request this and it would fit into the water rights issuance process. I don't remember if we put in the initial review or I think it has to come up before the proposed final order. And so then we would have that comment period and then the department, because you all don't issue the proposed final order, right? We do, right? Then we would issue a proposed final order with that assessment incorporated. And so it'd bring the processes together as opposed to having it be this, what I think is just a weird separate process. So I want to acknowledge, I think on minimum perennial stream flows and precedents, I probably should have looked at the rules again because I might be mixing some of these things up, but we will make sure when we bring it back that you have that. But that's my recollection on when we were thinking about how these flow together is like, why is there a separate decision? What do you do with that decision? Is that decision appealable? Why isn't it just incorporated into this order? Why are we having a hearing before we even know if we need to have a hearing, right? And so there is a number of things on there where like, this just doesn't make sense to how we think the workflow should be. And you'll see, you all will get to evaluate whether we made it make sense. So, yeah.
I believe we have another question. Commissioner Lee?
Thank you. This in any way doesn't deal with water reservations, does it? That's totally separate.
Chair Smitherman, Commissioner, yeah, these are separate processes.
Okay,
yeah.
Great.
Yes. Yes, for the record, Katie Ratcliffe. So, Vice Chair Smitherman, Commissioner Lee, reservations of water are found in our basin rules. And so we're not proposing updates to the basin rules at this time.
It doesn't come in when we process one.
Oh, it could. Yeah, that's so Raquel asked, does it come in when we process one? So if somebody applies for, say, a new storage application, which is part of our Division 310 process, so outside of 77, they can also submit supplemental information for their application, requesting that reserved water be used for appropriation for storage.
And so I guess completing the thought there, I suppose someone could then assert as part of that, hey, we want to use the reservation water and we want to assert this, I think. Is part of one application. So I guess I would say possibly, but this is not directly, right? Okay. The final rule division here or section that I would point out is that there is a rule section that talks about forfeiture of in-stream water rights, which has us scratching our heads because essentially we would be asserting forfeiture on we hold the water right. We would be asserting forfeiture on ourselves and protesting our own order, which that's just not how it works, right? The whole thing, we just thought, this doesn't really make sense. So this one's proposed for repeal. Moving to Division 18. There's a lot of these things are again procedural, but I want to point out two pieces that I think we're again going to change. One I talked about was the waiver of fees issue. So I already talked about that one. The other one is around groundwater rights. And so today, the department does issue allocations of conserved water based on groundwater rights. It is not something, I think it's a more recent practice and it's not something that occurs very frequently. I think it's under 10, I think we've done in total probably.
6 or 7.
So this isn't something that's common. It's not really outlined in the rule. I don't think it's excluded from the rule as it exists today. But what's interesting is you go back and you look at the statute, and the statute currently talks about water use is subject to transfer. If you look at the prior statute, it then pointed to surface water and groundwater water rates, essentially. So this one's a little bit more of I think a stickier issue, because I think there was a lot of surprise that groundwater rights could be used for this because we don't have a way to protect them in stream. So what we do is we cancel the state's portion, and folks have said, wait, that's not the same as protecting. But it gets very complicated very quickly, because then the question is, what do we mean to protect, right? And how would we actually, what steps would we actually take? So I think this is an issue that we will likely remove at this point in time, just given how much time we have to really dig into it and not put additional provisions in the rules. So those were the two items I wanted to highlight. Lisa, is there something else you wanted to highlight?
No, you did a great job highlighting that.
Okay. Finally, not finally, got two more. Okay, so Division 17, cancellation of perfected water rights. So this is the forfeiture statute. These rules clearly have not been updated in a while, and the statute has been updated several times. And that is a piece of why the consistency with statute. You'll notice 2025 is only one bullet on that long list there. And so the first piece we already talked about was the transfer piece. Another one that I've noted too, which we'll be clear about, this one does change that the director would rule on exceptions instead of the commission. And then getting into this consistency piece, there is provisions in the rules that imply that there could just be an assertion that someone would like us to look and see if there's cancellation. There's pieces in there that are not really the process that are for forfeiture. We need to believe that there's a preponderance of evidence, right, of forfeiture. There's also statutory exemptions. So interestingly enough, the ready, willing, and able standard that pretty much everybody in water law repeats is not in the rule. And that's because the rules haven't been updated. There's new drought provisions that are obviously also not in the rule that are more recent. These we're calling statutory exemptions, you'll note, instead of rebuttals, because they're actually supposed to occur before you could even say there's been forfeiture. So we would need to assess that there. There's also then the rebuttals, which I already alluded to earlier. And then there's two other provisions that are really about the rules being more restrictive than the statute. And so the first one is about what the water master can submit as part of, there's a statutory provision for the water master submitting affidavits of non-use for 5 years. So they have to do all 5 years in a row to the department as well as to the water right holder. And that one has some very specific things that would be included that would be pulled out, more consistent with the statute. The other piece is the current rule requires our staff, so this is separate from that very specific statutory affidavits process and statute. So set that one aside for a second. This is where it gets confusing. There is also a different authority which allows the department and commission to initiate forfeiture proceedings. Under those rules, it says that our staff must submit an affidavit to the department. So we must submit an affidavit to ourselves. And really, we're the ones issuing the proposed order of cancellation. Why are we submitting an affidavit to ourselves versus just making findings that we think meet the standard of the law? So those are the other two pieces there that I wanted to make sure we highlighted today. So with that, I'll pause. Just on this one. Forfeiture is one of those things where I make sure that, because I know it's important, right? This is someone's water right. We need to make sure we do get this right. So I want to make sure I pause for that. All right, so moving on to the Division 50s, 52, 53, 54. This one has a lot of similar things that you've already seen. So a lot of the changes, I guess, so one or more of the divisions do these things. We're trying to establish more consistency. We're trying to establish more consistency among divisions. I'll note that while the 2025 legislation, these are all ones that are developed in rule, right? So it didn't necessarily say we had to make some of these changes. We're just trying to create some consistency across the board. So you'll see there's a lot of similarities there. I will also note that these similarities are either based on what we can do under the Administrative Procedures Act. So if it's related to the contested case process, it's about what we can do under the Administrative Procedures Act. Some of the other items that are in here, such as the newspaper notice and weekly public notice, they were essentially duplicating what was in statute on those items in other laws. So removing those is a consistency piece. And the reason it's really important that I highlight that these are about the Administrative Procedures Act is because there are certain provisions that we do not, in the 2025 legislation, we cannot apply to these. So the contested case bill did not apply to Division 52 to 54. So to the extent we are changing pieces of the contested case process that look very similar to or are the same as the contested case 2025 legislation, is because we already had authority to do that. One, and two, we want to try to create as much consistency to reduce confusion as possible. Okay, so you made it. I think, as you can see, we owe a big thanks to our team. This is a lot of work. And these folks I'm just very impressed with. I'm very impressed with the folks in their divisions that are not sitting here today. We've got so much effort in coming from Jesse Ratcliffe at the Department of Justice. And just these folks have really handled such a big workload with such expertise. They've been flexible. And so I just really want to note that we just tremendously appreciate the big team that is not here at the table that is helping with this effort, as well as just noting these folks are really tirelessly working. And so I also want to thank the RAC. I know it was a lot of work, right? And they still provided great feedback. If you look at the documents, you can see that we made changes to the rules because of the RAC. I also expect the RAC will provide us with some RAC members may want to provide us with additional feedback as we go through this process. And we appreciate that as well. We also, as you've heard, we have a sense of urgency right now, right? We heard it very loud. For me, I remember sitting in the budget committee and I heard it loud and clear that this area really needs to be a priority, right? And that it could affect our budget down the line. And that, I think, really created this sense of urgency. We've got a director saying we need to do it and supports it. We've got an administrator that's saying it. And so I really think that is why you're seeing us move in an aggressive manner on this, is because we think we need to show progress and we need to show progress quickly. We also acknowledge that there's limits to what this rulemaking will do, right? We can't solve all of our processing timeline issues with a rulemaking, but we need to be able to show that we've done what we can with our resources. So I do want to just note that we understand the big lift here and that we look forward to further conversations on this rulemaking. Thank you.
Thank you, all four of you, so much for that report. lot to digest there, and obviously a lot of work went into this. As Raquel was mentioning, the teams behind you done an incredible amount of work as well. And so we just thank you for all the time and effort you've put into this. Do we have any questions or comments from commissioners? Commissioner Mull?
Yeah, I echo that. It's fabulous as much as I can understand it. And I say that half in jest. I hope, I'd request, suggest, because then this will be hard. So much of this is hard to digest because, and I can hear my fellow commissioners at different levels digesting and understanding things that they have clearly had direct involvement in. Someone who's been a part of an irrigation district and knows what they're doing, someone who's represented individuals who are getting permits and things. For the rest of it, not having had the experience of going through the process makes it really hard to understand a change. And so if there's a way in the ongoing presentation, and maybe this is, I don't know about the public hearing, but to sort of embody it so for whatever section you want to talk about, you start with, okay, imagine you are an irrigator and you have this water right and you want to move it to that, or something like that in the presentation would really help somebody like me. And that is a lot to ask because it's a flip in how you present information, but I request that you consider that at least for some of the more where you judge that the weight of the change and therefore the weight of the decision that we're being asked to make is higher. Consider that rather than weight it. I don't know. Does that make sense?
Chair Smitherman and Commissioner, yes, that does make sense. I will acknowledge this group right here. My biggest priority for them is working on the rules that need to get filed. And I think January, although I've told them there will be a little bit, it'll be slower. I think one of the key priorities is definitely making sure that we have information that is digestible for everybody. And so that is going to be a priority. There's some other requests I've heard from members of the RAC and from legislators. So we'll be working on trying to get that pulled together. And I think for the February commission meeting, our intention would be to do, this is your first time seeing this. Our intention would be to do another presentation that's not this one, right? That gets into those things. So that is certainly helpful to hear what you all would like. I will also note that all of the rules and rule changes and summaries are posted online. And I think what I would suggest for all of you is we will have, I don't think you need to go look at those right now. You're certainly welcome to, but we will, when we open the public comment period, we will send you all a draft as well. And happy to, check, if you want to walk through and understand some of these things, we are happy as well to have those conversations with you.
I was just going to say, rather than just requesting, I mean, I could offer to say, hey, tomorrow, if you want to say, hey, how does this sound or something, if we are able to do this outside of the timeline for release of public information, I'd be happy to do that. 5-minute conversation on the phone to say, hey, here's how we're thinking of presenting this. Does this make sense? Yes, no, that kind of thing on an ongoing ad hoc basis. I would be happy to do that, to help with that.
Chair Smitherman, Commissioner, I've heard that you would like to be our guinea pig for present whatever content we present. So
I think I heard that as well. Yeah.
Yeah, absolutely. I second that.
Thank you.
Any other commissioners? Comments, questions? All right, thank you so very much for that presentation. We do have a couple of public comment requests. So we'll go ahead and move into that. For this agenda item H, we have April Snell up first.
Good morning, or almost good afternoon as it is. For the record, April Snell with the Oregon Water Resources Congress. Just want to make a few comments on the presentation you just heard, which of course was very simple, very straightforward, didn't go over time whatsoever. I think actually the conversation and the questions you guys asked as commissioners underscores some of the things I was going to say. I am a member on the RAC representing irrigation districts and similar entities. I do want to thank particularly Laura, who was just up here, for the tremendous amount of work that she's done through this rulemaking process and being very responsive to requests that have been made. I have been doing water policy specific work and have worked for the Water Resources Congress since 2007. Aside from members on the commission, there's only one person in this room that has more experience than I do when it comes to engaging with this body and water policy. And I suspect you're going to hear from that individual after me. And I'm not to say that I know what they're going to say, but it's mostly to underscore that I've participated in a lot of rulemakings, both for this agency and others, and I have never seen one that had this broad of scope, and that gives me a lot of concern. And we will comment and give you specific substantive comments through the formal comment process. I am one of the stakeholders who is not able to give more specific comments as a RAC member just because of the timing. And as you heard, this process started in September. There were 9 formal RAC meetings over that process. And these rules, which you just heard about, are well beyond the scope of the 3 bills that were mentioned. Now, those bills, particularly the process improvements bill and the contested case bill, those are complex issues onto themselves and merit the time and attention of the rulemaking meetings that we've had so far. Going further than what we have is in the manner in this short period is a disservice to the department, to the members that are participating. And I think as well as intentioned as the staff efforts to try and do more and pick out some things that could help things be more consistent. Whenever you do this many rules in this short a period of time, you run the risk of having additional problems that come up. Words that you find out later weren't supposed to be there. And I don't think folks, including myself, are going to have the time to go through these rules in that level of detail to avoid there being more issues. There are also other opportunities for making additional process improvements with the department and things that would be helpful to various stakeholders, not only the folks I represent, but I'm trying to think of this in the in-stream, out-of-stream, what's good for all of us. And we'll leave my more specific industry comments for the public comment period. But when we don't have discussions about ways we can actually improve things, we're just going to create more problems. So the 2 bills were discussed during the legislative session, but prior to the legislative session, there was an effort by the department to have a work group to talk about various process improvements. I think there was maybe 2 or 3 meetings before that was discontinued because we needed to focus on fee increases and preparing for the legislative session. I mention that because that would be a way where if you want to figure out what's something that works for irrigators, for communities, for conservation interests that can actually yield some efficiency, put us together and let us talk about those things. But instead, I feel we're being forced into this really extremely short time frame to give a lot of feedback, and that doesn't lead to very good opportunities in the future. In the absence of having clear rules, statute will always be the guidepost. So while I do understand that one of the bills has the April deadline of next year that's largely driving this extremely short time frame, even in that particular instance, the department could go forward without having perfectly clear rules. I'm not suggesting that, but I really do feel strongly that the department should pull back on the rules that aren't required by the specific legislation. Now, I do think Division 77 is an example where that wasn't required by the bills from the 2025 session, but there was 2 rulemakings previously, both of which I served on, that had a lot of conversation. So that's a kind of an exception where that might have made sense to put that on top of it. But when you put that and layer that with I don't know, 12 other divisions, that makes it again where we're not having the time as a group to be able to adequately go through all of those and avoid that. Lastly, I'll say that perception matters, process matters. And as someone who I would like to think has a decent understanding of a variety of processes within an department, this has been an overwhelming one. And so it's hard for me to explain to my folks not only what the department is doing and why, but they have concerns that what they're seeing is this is a way for the department to just say no more often, to reduce backlogs by simply avoiding the issue altogether or just pushing it off. And that's not going to be good for long-term water management in the state. And I don't think that was the intention of the legislatures in passing the legislation or the commission. So you're going to get a lot of comments, and I think there will be some opportunities for department staff to revisit the rule divisions that they have discretion over and hopefully pull that back in a way so that we can focus on the rules that really do need to be done. And I'll say we do need to have more opportunities both for work group discussions outside of the legislative session on how we can improve things collectively with all the different stakeholders at the table, whether it's through the IWRS or some other table. But also there are a list of other rules that I'm sure the department staff could tell you about that also need to be updated. So it's misleading to say that we need to do all of these rules right now. And it's also, I think, important to recognize that there is a huge backlog of things that need to be addressed. And if we're going to be successful, we need to take manageable bite-sized pieces at that. So it is a lot. I do really appreciate the staff's efforts, and you'll hear more from us in more specific detail, but I just wanted to flag those concerns. Thank you.
Thank you, April. Do we have any comments or questions for April? No, appreciate your comments. Okay, Kimberly?
Good afternoon, Chair Smitherman, members of the commission. For the record, my name is Kimberly Priestley, and I'm here representing Water Watch of Oregon. Water Watch is a member of the Omnibus Rulemaking RAC. We have participated in all the RAC meetings. We have submitted detailed written comments on all the rule divisions for version 1 and version 2. We are here today to offer very brief comments in support of one aspect of this rulemaking that we feel deserves a big shout out, and that is the department's review of all of these rules to bring them into compliance with statute. The department has a number of rules that have not been reviewed in decades. Many of these include rule language that not only doesn't align with statute, but in some cases is directly conflicts with statute. And we think that this is a great opportunity to clean up these rules, to bring them into alignment with statute. I think as the state moves forward to modernize water management, one of the most basic things that it can do is make sure that the rules align with statutes. It's just, it causes problems at all levels of water right processing or whatnot. So again, we would just want to be clear on the record, given that there have been comments both in the RAC and here today, that we definitely support that portion of the rulemaking. That said, along the same lines, while we strongly support cleaning up the rules to align with statute, we do have concerns with some of the new provisions that are not found in statute. We think we would urge that we pull back on those because I think that would be outside of the scope of this rulemaking. These include things like establishing this new concept called living certificate, something that's not found in statute anywhere. We also believe that pre-notice to any interest in advance of in-stream water right filings. That's not something found in statute anywhere. So there are a number of other provisions that are new that aren't cleaning up the rules, but are actually adding things to the rules that don't comport with statute. So, we will be commenting on that, but we would ask you to look out for those. And again, on that, I will just say on that point, if interests are interested in advancing things like that, in our minds, the proper place is the legislature to get that language in statute first, and then they can, then we could have rules to address it. Again, we've provided detailed comments. Those are found at the end of every meeting summary on the web. So if you want to look at our detailed comments, they're there. And then I will just close by saying that the work of this staff in this rulemaking has been so admirable. They have been diligent, responsive. They have put together documents for the RAC that make it incredibly easy to follow the changes. So we just want to express our appreciation to the department. It's been, really great for us. This is a huge lift, but they have made it doable in our mind for us. So just want to thank you. That's it.
Thank you, Kimberly, for the feedback. I'm sure staff very much appreciates that, and we do as well. Did you have a real quick? Okay, wait, not a question for you, Kimberly. It looks like it's just a comment
Yes,
from
I just
Commissioner
wanted
Lee.
to say that in addition to hearing from Kimberly and from OWRC April as well, that there were a number of other entities who also had concerns about expanding the rule process, the cities, the special districts and others. So we'll probably hear more information from them about what specific areas were of concern.
Thank you, Commissioner Lee. Yes, Mindy.
Thank you, Vice Chair. For the record, in the chat, we had a public comment from Brent Stevenson, Santiam Water Control District. I would like to make the department aware the Santiam Water Control District has a standing protest filed against the original North Santiam River minimum perennial stream flow filing.
Okay, thank you. Noted. Any comments from commissioners on that at this time? Okay. Yes.
Just on this item, it was fascinating because on one hand, hearing from both April and Kimberly over the years, the description of many of the things that I even recognize, even though I don't understand necessarily implication, that many of these things have popped up in meetings on the 5, 6, 7 years I've been on the commission. So on one hand, I feel like, well, wait a minute. They've been out here as issues. It's not like many of these things are just being pulled out of a hat, and so arguably those that are deeply immersed in it, I think would reasonably have a firm enough understanding that it does make sense. Hey, let's address these now. I hear the concern about process and time to reflect, which is something we hear about all things, all public process. That's always been raised as an issue, but I guess I lean towards, yeah, let's do this as best we can, knowing that it's not going to be perfect, that we will make mistakes, but considering the familiarity. Oh yeah, I remember that. I remember. Oh yeah, I remember why we couldn't act on something because of that before. I, for one, want to encourage continued pursuit of as much as is good and reasonably possible. Appreciate your all's judgment and discretion on that.
Thank you. Okay, I think that concludes agenda item H. How's everyone doing? Is there a need for a 5-minute break before we move on to the director's report? You're okay? Or you would like a break? Real quick. Okay, we'll do a quick 5-minute break and then we'll come back for agenda item K. I think we are ready to get started again. Thank you. All right, moving on to agenda item K is our director's report. Director Gall.
Vice Chair Smitherman, members of the commission, again, pleasure to have you all here in Salem. You've accomplished quite a bit over the last couple of days. In follow up to that last presentation, I was kind of looking at my watch and thinking we're probably coming up on Sunday. So there's a lot of information to go through there. And, the team is going to do everything they can to keep things succinct, but there's just no way around the fact that you will be facing hundreds of pages of updated rules. Not all of those represent changes in upcoming months there. So I appreciate your thoughts on that. I think to start out here, I just want to kind of publicly thank my team who's been working so much in the Harney Basin over the years and on the Division 512 rules. And then also thank Raquel and Katie's team for these 18 rule division updates. Both of those endeavors really represent significant policy updates and a tremendous amount of time that's both of which were well orchestrated and managed to be as efficient as possible, but are dealing with a large volume of material there. I did want to follow up a little bit. Raquel and Katie and their team on the 18 rule updates, they're closely following my instructions here. We do really need to act now to garner the value of updating these rules in making our processes more efficiently. We will be held accountable to improve our delivery of customer service. And I need to be able to assure the governor and the legislature that we have done everything available for us to deliver on improved customer service there and reach that goal. As was also mentioned, we have a tremendous backlog beyond these 18 rule divisions of outdated rules and other policies that we really need to free up staff capacity for to continue this process. So as far as managing expectations for you as commissioners and for our interested parties that we work with, they will see a continuous conveyor belt of rule updates for years coming out of this agency. And we're going to do everything we can. Everybody gets overloaded during the long legislative sessions. Those are really a heavy lift for all the folks that work in our water sphere. So we're going to do everything we can to not launch anything or have anything substantive occurring during those 6-month windows of time. But the other 18 months across a biennium are going to be loaded up pretty good with rule update processes there. And again, we'll do the best process we can. I don't think anything will be as volumetrically significant as what we're seeing in this current 18 division process there, but there still is a lot of work to do. We will continue to take in input from our interested parties out there. As Raquel noted, folks raised a number of issues during this update process. Those were just out of scope for this particular rulemaking, so those are tabled. There are also a couple of complex issues. Land use is one of them. And so we're evaluating on how best to address that. But I think as you all will be seeing at our February commission meeting with DLCD, we certainly have our Division 5 rules, which are 35 years old, as well as the state agency coordination plan, which I believe is also 35 years old. So those are a couple of very relevant things that we're also going to have to get on that update list there as well. Let's see, starting out with the written report, I did want to draw attention to item F in the director's report there, the static water level measurement and reporting. Kim Fritz Ogren, working with her field services team and folks from the technical services division, sent out 576 notices of violation here in November to groundwater users who have groundwater permits with static water level measurement conditions in them, and for which we received no data in 2025. So a notice of violation, again, it's a sternly worded letter that puts them on notice that they need to submit a spring water level measurement for their well or wells in the upcoming spring of 2026. In the event that we don't receive anything from them, then our team will go ahead and continue with additional enforcement activities to make sure that we get these data. The data that we're chasing represent about a 2 to 3-fold increase over the groundwater level data that our own team is collecting internally here. So it really can help significantly improve the statewide coverage and our assessment of aquifer trends around the state. And that's one of the reasons we're focusing time on it, is because it's so important there. So I wanted to draw that out. It's a significant new endeavor. I will clarify that we have been sending out request letters, reminder letters for years to these permit holders. And so we're just kind of ratcheting this up to the next level to make sure we get those data submitted to us. Okay, I'm going to touch kind of quickly here on 2 new executive orders from Governor Kotek. The first one is Executive Order 25-26. This was signed October 21st and directs state agencies to take urgent action to promote the resilience of our communities and natural and working lands and waters. I pulled some key language out here. I'll just run through quickly. Agencies shall foster resilient lands, waters, and communities. And we need to define key resiliency attributes for land and waters that are currently resilient to impacts from climate change and therefore able to deliver multiple benefits that are likely to persist under future climate conditions and that are capable of achieving multiple benefits of high resilience in the face of changing conditions, if supported by actions that promote restoration, enhancement, or reconnection of those lands and waters. So Director O'Brien at OWEB and Director Colbert at ODFW are going to lead a team to develop these resiliency attributes. And that includes determining the baseline conditions against which future progress will be measured. The goal is for agencies to use the resiliency attributes to identify and improve our programs, processes, and practices that protect and promote stewardship of working lands and waters to adapt to impacts from a changing climate. Agencies are directed to protect, conserve, connect, or restore 10% of lands and waters in Oregon within 10 years as compared to baseline conditions for 2025. So that's kind of known as a 10 by 10 approach there. Jeff Huntington and Chandra will be joining us from the Governor's Natural Resource Office in February to provide more information to the Water Resources Commission and the DLCD Commission there on this particular executive order and implementation plans. So there's still much to be worked out on the specifics of that, but I thought you'd be interested in it, and we're likely to play a substantial role, I think, in the work associated with that.
Director Gall, could I ask a question about that? Determining baseline conditions, could you elaborate on that a little bit?
Vice Chair Smitherman, members of the commission, I would speculate at this point in time that as this interagency team works on resiliency attributes, once those are identified and defined, we can then take a look at the baseline conditions associated with those that we see across the landscape today. And then that 10 by 10 goal is in the next 10 years, try and improve those by 10%.
Okay, thank you. Commissioner Lee?
Yes, Ivan, when we meet with LCDC in February, could this be a topic for some minimal discussion as well? Because the land related to the water on this is going to be very significant.
Vice Chair Smitherman and Commissioner Lee, I think it would certainly be an appropriate topic for that. Alyssa Meckin with our agency is working with DLCD staff now to work on an agenda of potential topics. I think we'll be evaluating a tour potential. I can't think of anything right now that's a good land use water nexus. Hoping somebody else can, if weather permitting, and we can find something here in the local Salem area. But I think this executive order certainly is relevant to the discussion that we'll be having there. And Yeah, you know, as we think about one of Governor Kotek's goals is increasing housing. That gets into the nexus then of wetlands, fill and removal, you know, spreading out across the landscape in some areas, as well as infilling there. And I've started discussions with Director Lavelle at the Department of State Lands, you know, as a part of wetland mitigation programs and things like that. There's a nexus there with water use and water right permitting. And so we need to get some clarification around some of those things to try and get ahead of some issues we're seeing come up across the landscape there. The second executive order I wanted to touch on was Executive Order 2529. So this was signed November 18th and is reducing greenhouse gas emissions and advancing Oregon's clean energy future. So the order directs executive branch agencies to advance the 5 least cost pathways that have been identified in the Oregon Energy Strategy. The objectives include advancing energy efficiency across all sectors, supporting investment in clean electricity infrastructure, increasing strategic electrification of vehicles and buildings, increase supply and use of low carbon fuels, and strengthen resilience across all levels of the energy system. Also work to include getting clean energy projects built and building a resilient clean energy economy. The key agencies that are going to be involved there are the Department of Administrative Services, Department of Energy, DEQ, DLCD, ODOT, PUC, and DOGAMI. We're going to be probably more tasked with providing information and consultation to assist these other state agencies with the implementation of this order. But agencies are to begin developing implementation timelines and pathways to comply with the order there. So I'll stop there, see if there's any questions on that one. Okay. Share a water condition update. Appreciate Annette staff for pulling this together for me. So as of December 2nd, more than 31% of Oregon is experiencing moderate to severe drought, and over 74% of the state is classified as abnormally dry. These conditions reflect not only below normal precipitation observed so far this water year, but also the prolonged precipitation deficits carried over from last water year. Together, these deficits indicated developing long-term drought signal across much of Oregon. Temperatures have also been above normal early in the water year, contributing to significant snowpack shortfalls. As of December 9th, snowpack levels are well below normal in every basin of the state, with our statewide snowpack at just 18% of the historical median. Although there's still time for snowpack to recover, the existing precipitation deficits will be increasingly difficult to overcome as the water year progresses. So as I like to say, it's a little too early to start getting nervous, but conditions aren't stacking up in our favor right now. Let's see, on November 21st, the Burns Paiute tribe submitted to us a draft MOA to develop a water resource co-stewardship agreement with the Water Resources Department. We're continuing to review that draft, and we'll report back to the commission on progress there. Chair Kennedy with the Burns Paiute tribe and their staff are anxious to work with us on water management challenges in the basin. This partnership can assist with finding resources also through joint application processes for grants. So we'll keep you up to date as that develops there. And just in closing here, I'll share with you, I attended a couple of conferences last week. The Water Resources Congress had their annual meeting in Hood River. I appreciate the invitation to go out there and speak with folks. And then Kim Fritz-Ogan and I attended the Oregon Cattlemen's Association meeting in Pendleton on Friday of last week. We provided talks on both of those venues there on agency updates, what are the priorities that we've been working on, and then the rulemaking processes we're going through. I'll be heading out to Richland, Washington next week for a tri-sovereign meeting with Confederated Tribes of the Umatilla Indian Reservation, and also the Washington Department of Ecology and Office of Columbia River there. So that's all I have for you. Happy to answer any questions associated with any of this or anything else.
questions? Commissioner Mull?
A narrow question on that 10x10 strategy. Has there been any discussion, any reference to the federal 30x30 strategy and any integration with that?
Vice Chair Smitherman, Commissioner Mall, I'm not aware of any associated with this executive order.
Okay.
I'm sure Jeff and Chandra will be able to provide some additional context there.
Thanks.
Thank you. I think that the efforts on compliance with the static water level measurement requirements is a great effort. And I'd like to encourage us to find other pockets of business within the agency where we can take that more assertive action on compliance as well. It looks like we're going to have some interesting things to think about on the Deschutes mitigation program as we go forward. Maybe that'll be one of our next big decisions. And I just wanted to encourage the commissioners to, we received with your director's report draft provisions for voluntary agreements. And I just want to encourage all of us to read it now with yesterday's meeting in mind and see if there are additional things that we think should be there or should not be there or could help make things more palatable and flexible for some of the folks in the Harney Basin. And I view the litigation matrix with dismay just because it's so long and big, but it is what it is.
Vice Chair Smitherman and members of the commission, following up on your comment on the voluntary agreement documentation there, if you feel a need for additional information or would like to have additional discussions with staff around management in the Harney Basin, please let me know and we can get those scheduled for you. Happy to set up workshops, talk about additional simulations, all of those different opportunities to you look at things. We're going to have some time as this process unfolds. There is a lot of work for staff to do, so I don't want to be overly burdensome to them, but I also want to make sure that you have the information in front of you to help you make decisions. And it's a lot, it's complicated at times, depending on what we're talking about.
Yes, thank you. Any other comments, questions? All right, thank you, Director Gall. We will now move into our one of our final agenda items, which is commissioner comments. And I'm going to start with Commissioner Lee.
Yeah, thank you. I'm sorry I will have to leave at 1 wherever we are, but I'll listen on my phone. I like Director Gall. I've been going to a number of conferences related to water. Very appropriate for some of us to see if we have the opportunity.
Vice Chair Smitherman, Commissioner Lee, we're aware of the webinar. I know Bobby and some of his staff interviewed a handful of our staff as part of that process there as well.
Oh, good. Look forward to it.
All right. Thank you, Commissioner Lee. Commissioner Newman?
I don't have much to report other than I am diligently trying to get my updated edition of my water law treatise done, made more complicated by the legislature and all the changes and recent court cases. So I've had to go back and do some scrambling to revise, but hopefully that will be out in a few months.
Thank you, Commissioner Newman. Commissioner Kihara?
I don't have much to report either. The nervous looking at our very brown mountains. I don't recall a winter that has been quite as dry as this one. So I'm already nervous. And the fact that most of our precip, what we have been getting, has been falling as rain is something that we need to be looking at how we operate our reservoirs, et cetera, because I think this is probably going to be a more common phenomena in the future. And we really need to think about how do we operate our facilities so that there's, water available come summer for irrigation? What do we need to be, how do we operate for flood control? Because the timing may be different than what our current rule curves are. And that's probably something that we need to be working with Corps of Engineers, Bureau of Reclamation, as well as our own dam safety folks as to, okay, how do we deal? It's just something we need to be keep in the forefront of our minds. And that's really all I've got. Thanks.
Thank you, Commissioner Kihara. Commissioner Mall?
Thank you, Chair. I wanted just to repeat what I had said yesterday, that my thanks to the department and the particular department staff that were involved in the Our Willamette 2025 conference in Corvallis. Hopefully that's something that will continue to build, and even just what you brought up, Kathy, the Corps' work on their what's called forecast informed reservoir operations, greater adaptation in the face of things, as well as the complexity that the BIOP now brings to stored water allocation. I mean, it's all there, and I think that those sorts of settings just sort of lend themselves, as I said yesterday, to meaningful interaction across agencies and nonprofits and things like that. I think that I take that example as how I really would love to encourage department staff, and you, Ivan, especially, to find ways to bring that to bear, not just in the Harney particularly. There are some particular things now that I think can be done to not just simply be well, what can the department do, but how can the department become a convener of the nonprofit world, of private philanthropy, of broader citizen interest across Oregon in resolving some of those, the impacts that we're going to likely see on some of the operators, on some of the local businesses, but also recognize, as we talked about yesterday, just how quickly things are changing around the state, economically and otherwise, and just giving staff the legs and discretion to put on their creative thinking caps and dive in there. Because I think it's going to take years of work to do that. It's really encouraging to hear about the co-stewardship discussion with Burns Paiute, and I think that there is a great deal of, interestingly, continued effort at the federal level still, with the change in the administration across Indian country on federal level co-stewardship, co-management arrangements, and seeing just how that has also affected discussions at the state level and at the private landowner and land conservation organization, land trust level. It's a really exciting place to be, and the nexus with water is just everywhere there. So I'm really glad to see that that's coming together. And I'll leave it at that. Again, just thanks to the staff for another great meeting and for all of the work that you all do every day to make this possible. Thank you.
Thank you, Commissioner Mall. And Commissioner Wolf had to leave, so I'll just finish up our comments with there's some activity going on in the Rogue Basin. Work is being done to bring together several water stakeholders from different backgrounds with the intention of working towards some place-based planning, which is really exciting for our region. We've got a lot of people who are interested and involved in getting together and just at least starting a conversation. There was a big forum that was held back in September that kind of kicked off the movement in that direction. And it's just another, again, whether they go forward with place-based planning or not, it's another opportunity for all people in all these different water sectors to come together and try to understand each other's needs. So I'm excited to see how this goes in our region, and we'll report back once I hear more. And that's my comments for today. Well, I also want to thank staff. These meetings I know take a lot of effort, and all the work that you put into the presentations, very much appreciate it, the detail, the thoroughness. I also want to thank Mindy and Cassidy for all their work behind the scenes. They're keeping this thing running, bringing me water, which I thank you. As I had a little frog in my throat. And I just thank you for all that you do to help us get organized and run these meetings in the background. So appreciate all the help and all the work from staff. Thank you. Yes, Commissioner Mull.
Yeah, may I add one thing, and it's an invitation. The agenda is not set yet, but the ODFW Commission is going to be meeting in Eugene in February on the 19th and 20th. And I'm pretty sure on the 20th, they're going to be looking to spend time in the Upper McKenzie Basin, where they're going to be looking at dam operations, flow, as well as some of the large floodplain habitat restoration that also is being projected as really helping with attenuating flood, holding water in the basin, some of the things that especially former Commissioner Eric Quimps talked about a lot. So if you are interested in that, I know we'll have to be thoughtful to quorum, but if you're interested in that, give me a call and I can help, because members of the public will be invited, and so you could be coming as members of the public.
Okay.
Again, that's the February 19th, 20th, Thursday, Friday. I think it'll probably be Friday that we'll be in the field, but that's not sure it's set yet.
Okay, great. Thank you. And so that concludes agenda item M, commissioner comments. And now we move to agenda item N, public comment and other issues. I do not believe we have anyone signed up for public comment at this time. Okay. Well, with that, once again, thank you for all the work. We've had a lot to work on these last 2 days, and we'll be meeting again in February. So until then, this meeting is adjourned. Thank you.